have that right. So we ain't giving up no mountain. We ain't giving up. We ain't giving up no tree. We ain't giving up. We ain't giving up no river. We ain't giving up. That belongs to we. Not one blue sake. Not one rice grain. Not one rice. Not a blade of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake. Not one rice grain. Not one chorus. Not a blade of grass. We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake. Not one rice grain. Not one chorus. Not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here, and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain. We ain't giving up. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake. Not one rice grain. Not one rice. Not a blade of grass. We love the open country of the Rupununi and the Essequibo, daytime or night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain. We ain't giving up. We ain't giving up no tree. We ain't giving up. We ain't giving up no river. We ain't giving up. That belongs to we. Not one blue sake. Not one rice grain. Not one chorus. Not a blade of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake. Not one rice grain. Not one chorus. Not a blade of grass. We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river. That belongs to we. Not one blue sake. Not one rice grain. Not one chorus. Not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, cause we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time when though we may criticize it, this is our home, we love it, and we need to keep it. We have that right, so we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Make no mistake, cause we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time when though we may criticize it, this is our home, we love it, and we need to keep it. We have that right, so we ain't giving up no mountain. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. So we ain't giving up no mountains. We ain't giving up no tree. We ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one rice, not a blade of grass. We are a peaceful people. Struggle is we struggle, and we don't look for trouble. Just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one karage, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here, and they lived and died here, and we ain't moving nowhere. Make no mistake, 'cause we ain't giving up no mountain.
Thank you, honorable members. Please be seated. Honorable members, we will now proceed with the second reading of the Representation of the People Amendment Bill 2022, Bill number 24 of 2022, published on the 1st of November 2022. The Honorable Attorney General and Minister of Legal Affairs.
Mr. Speaker and honorable members of this House, I rise to move that the Representation of the People Amendment Bill, Bill number 22, Bill number 24 of 2022, be read for the second time. Mr. Speaker, this bill and the one that will immediately succeed it are two of the most important pieces of legislation that we will be discussing perhaps in the next few years as they seek to enhance, modernize, and reform the democratic polity and architecture of our country, and in particular to make our electoral machinery, our registration process of citizens, and the compilation of the list of electors more transparent, more accountable, and more effective. Mr. Speaker, the bill that is before us has been in the public domain for some time now and has been the subject of much public commentary. Therefore, no one in this House, or by extension listening to this debate, ought to be unfamiliar with the contents of this bill. But for the purpose of the record, it is important that I state that these amendments were immediately triggered by the unfortunate incidents which marred the 2020 March 2nd general and regional elections, where flagrant attempts were made to thwart the democratic will of the electorate. So much so that the head of the OAS mission to Guyana, a former Prime Minister of Jamaica, said that it was the most transparent attempts to alter the lawful results of an election that he has ever seen. Mr. Speaker, that precipitated our political party, when we were in the opposition, and then when we were declared the government, to make three fundamental commitments through His Excellency President Dr. Mohamed Irfan Ali. Firstly, we promised these electoral reforms. Secondly, we promised that the investigative arm of the state will be activated and criminal charges will be instituted if there is evidence to support those charges. And thirdly, that a commission of inquiry will be launched under the hand of the president to inquire into the facts and circumstances surrounding the irregularities that took place subsequent to voting day in relation to those elections. The investigative arm has been activated as promised, and there are currently pending before the criminal courts of our country some 32 charges against persons implicated in the alleged wrongdoings which we all witnessed. That is an ongoing process. So that's commitment number one, delivered upon. Commitment number two is the Commission of Inquiry, and that is also a work in progress. And now, Mr. Speaker, we are delivering on commitment number three, which are the legal reforms that we are proposing here tonight. Mr. Speaker, the road to this destination has been a long one. This bill and the bill that we will discuss subsequently enjoyed several rounds of consultations involving and engaging many important stakeholder organizations and receiving the inputs from those organizations. The bills themselves were sent out to various of these organizations, and they were given ample and adequate time to scrupulously examine them and to submit their contributions to the bills. Those contributions were examined and taken on board when it was considered necessary to do so. And then we concluded that consultative process with a grand consultation right here in the halls of this house, where some over 100 persons emanating from various important stakeholder organizations were present. And they benefited, Mr. Speaker, from a marathon 5-hour engagement. Again, recommendations and submissions were taken on board, and the bills benefited from them. Mr. Speaker, the first thing that I want to address is the state that our laws were in even before we began the amending process. Our electoral laws, unfortunately, have been passed over the last 25 to 30 years in a very piecemeal fashion. So you have several pieces of amendments scattered all over the legislative landscape, amending ROPA, amending the National Registration Act, and then we had the anomalous situation where we had a bill called Election Laws Amendment Bill, or Election Laws Amendment Act, that was passed in 2000, that presents itself as an amendment, but in fact it was a principal act, as there is no principal act in the country called an Election Laws Act. And that act became the cradle of a whole slew of important provisions relating to the Elections Commission, the electoral process, the powers of the Commission, the establishment of a permanent secretariat, the power of the Commission to take charge of that secretariat, the power of the commission to hold the chief elections officer answerable, the power of the commission to hold the chief election officer answerable even for the hiring of staff, the provision to empower GCOM to deal with situations of emergency and difficulties after there is a recession of parliament and there is no legislative body to intervene to make laws. All those wide and very crucial plenitude of powers were assembled in this one piece of legislation called the Election Laws Amendment Act. And then, as I said, the National Registration Act was amended several times when we introduced into our registration system the cyclical form of continuous registration, abolishing the acyclical form of registration which existed hitherto. And even that, when one reads the letter columns of the newspaper and hear the political narrative emanating from the opposition, one gets the distinct impression that there is great misunderstanding still yet in appreciating that we have a continuous cycle of registration. And that difficulty comes from the scattered and piecemeal way that our law finds itself currently now. Any person who has had the opportunity or the occasion to research our law would tell you the difficulty and the tedious nature of the exercise simply to find the law and then to understand which one impliedly or expressly repealed which one have not been repealed and which have been repealed. Lawyers doing election cases and cases of a political nature have had the miserable ordeal of deciphering pages and pages of legislation. And then, of course, one had to find them in the first place. I recall distinctly when I was arguing the case in 2019 in relation to the then house-to-house registration process commenced by Chairman of the Elections Commission at that time, James Patterson, the Chief Justice of our country, the Honorable Madam Justice Roxanne George, expressed great disquiet at the state that the law was in, because it was so difficult to assemble the various pieces of legislation and then to try to understand them in a coherent and chronological way. Half of them were overtaken by events because they were passed to meet peculiar events that would have been contemplated or expected to take place or to feature at a particular election time or a particular elections. And when that elections passed, that eventuality no longer existed, but that provision or those provisions remained on the statute book, creating unnecessary ammunition for lawyers who want to advance disingenuous arguments because the law is there and they use that to make clear positions ambiguous by injecting these different and varying and various pieces of legislation. What this exercise enabled us to do, Mr. Speaker, was to examine all this gamut of loose pieces of paper all over the landscape, to examine them scrupulously, dissect from them the irrelevant provisions, those that may have been overtaken by events, put aside those provisions that have been repealed, and to consolidate or revise, as is the technical term, all those various provisions. For example, the Election Laws Amendment Act of 2000 had about 30-something or more provisions. We had to migrate them back to their respective homes, either where appropriate, either in the ROPA or in the National Registration Act. So, Mr. Speaker, even without the amendments, this exercise has been great for our law revision process in that it has now, for the first time after approximately 3 decades, assembled all of our election laws and registration laws and related laws to those two processes. We are now putting them in their respective abode so they can be easily and conveniently accessed. Even if we have accomplished nothing more than that, I believe, sir, that we have accomplished a great lot. But these amendments go much further than that. Mr. Speaker, the bill that is before us is 63 pages in length, and the amendments that are contained therein are wide-ranging, and they cover from the beginning to the end, almost, of the ROPA. It is therefore physically impossible for one to go through clause by clause in this bill. One will only have to deal with the conspicuous and salient aspects of the reforms that are being proposed. So, Mr. Speaker, the first component of the bill deals with the various sections of the Election Laws Amendment Act and to reside them at convenient places within the ROPA. So you have a series of provisions here that we are now inserting into ROPA as they are relevant to ROPA, which were found or which are in the 2000 ELA, Election Laws Amendment Act. And we have done similarly for the National Registration Act. And they are all there, the establishment of the Permanent Secretariat, and these are all in the laws already. It is just to situate them appropriately. The clarifying of the commission powers over the commissioner, and importantly, Mr. Speaker, one of the main policies, and perhaps I should speak to the main policies of this bill. Let me digress a little to speak about the main policies of the bill. Mr. Speaker, ROPA is nearly 100 years old, and by sheer passage of time, would have required a review in any event. However, elections 2020 brought to light the way that the legislation in its current form can be subject to abuse. Mind you, this is the very legislation that governed all the elections, including 2015, which the joint opposition won and formed the government. It presented no problems for the returning officers working in that electoral machinery. It presented no problems for the very chief elections officer who administered the 2020 elections. Both of those categories of officials and all others seem to have understood their functions quite well and performed them quite creditably. Come 2020, March the 2nd, election day was well. President Granger, speaking on behalf of the government, lauded the activities of voting day. And so did all the political parties contesting the elections. So did all the major international observer agencies and local observer agencies observing D-Day activity, E-Day activities, or D-Day, whichever wish. E-Day, I believe. It was when the tabulation of Region 4 began, then the mad orchestra began to play. 9 other regions tabulated their results and transmitted their statements of poll and the consequential legal documents to the center under the legislation without any significant complaint or difficulties. It was when the tabulation of Region 4 began that we saw a different story unfolding. And it gave us, and it gave the world, an opportunity to see how discretion can be abused, how discretion can be manipulated, how irrelevant considerations can contaminate the exercise of discretion, how ill motive, how fraud can contaminate the exercise of power. But it did not start there. It began before with an unlawful house-to-house exercise in 2019, where the GCOM wanted to scrap the existing database and construct a new one, and carried out a house-to-house process which in record 6 weeks purported to register, according to them, over half of the electorate. When we took a full 2 years in 2008, the last time such an exercise was undertaken, to complete the entire country. What was found out in that aborted house-to-house exercise was a clear and present intent to alienate a number of qualified persons to be registered, so that you would have had a very limited and deficient base from the National Register of Registrants from which a voter list would have been extracted, thereby rigging an election even before it was called. That was the first problem that surfaced. Quite apart from the unilateral appointment of the GCOM chair, I have to abbreviate my presentation to be focused. So that was challenged in the court, and the court ruled, as we all know, that you cannot remove existing registrants from that database, especially, or rather specifically, if they were not resident in the country, because that was the stated purpose of the exercise: to remove from the database persons whom GCOM felt are not resident in the country. And the rationale is simple. The combination of Articles 59 and 159 of our Constitution imbues to every citizen, or imbue to every citizen of this country, a power to register once that citizen is 18 years and over, once that citizen is a Guyanese. No mention of residency, meaning that if you're a resident in Timbuktu, if you're a resident in Sri Lanka, if you're a resident in the United Kingdom, once you are 18 years and over and you're a Guyanese, you can come here and be registered. And once registered, you are qualified to vote. Very simple equation. Very simple. So, Mr. Speaker, we had to then deal with that issue, and that is reflected in the amendments here, as well as in the amendments in the National Registration Act. Wherever residency, we have a duty as lawmakers to ensure that Article 8 of the Constitution is complied with. Article 8 of the Constitution says that any law that is inconsistent with the Constitution is void to the extent of that inconsistency. When we are making laws, we have to ensure, or amending laws, we have to ensure that those laws meet the constitutional litmus test. There are many instances in the current Registration Act and in the ROPA, when it relates to the compilation of the list of electors, that place, rather misplace emphasis on residency. Wherever that has occurred, Mr. Speaker, it is now being removed to bring the legislation, both ROPA and the Registration Act, in conformity with the four corners of the Constitution. So that's a major thrust of these amendments. Second, Mr. Speaker, the public would be well aware that the chief elections officer has a great unnecessary latitudinal width and breadth of power when it comes to the appointment of polling places. GCOM took a policy last election and possibly previous elections too. A policy I have no doubt was made with the best of intentions, that they will use as far as possible only public places as polling stations. However, you have places in this country where there may not be a sufficient number of public places. Therefore, you have to, by necessity, to ensure that there is available voting stations for the electorate to exercise their franchise, you have to rent private places. What we found on the last occasion, not what we found, what we made public, was that areas in Georgetown, for example, where there are far more public places that could have been used for polling places, private residences were used. And in my constituency, on the east coast of Demerara, where there is a distinct paucity of public places, polling stations, sufficient number of polling stations were not appointed. When we queried the executive agent, election agent of the PAP, Comrade Zulfikar Mustafa, and I am an assistant election agent, when we queried it to the then chief elections officer, he gave me that excuse that they are confined only to rent, to deal with public places. I traveled around Georgetown and I photographed over 15 private residences that are in close proximity with public places, but those private residences were retained or rented and the public places were not being used. And I presented that to him. And I said, this cannot be fair. Then we had to take a team from the Elections Commission, accompanied by APNU AFC. Basil Williams was part of that team. I can't remember who else. The consultants from the Commonwealth, myself, Mr. Zulfikar Mustafa, and a team from GCOM. Because we had to travel to the East Coast to show the length of villages and to show where the polling places were located. Firstly, they were inadequate in number. They were not properly geographically located, so there was not an equitable spread. But quite apart from the geographic spread, to make it convenient for voters, there was a minuscule number, totally inadequate to satisfy the voting population in localities. So that was a major problem. And what was even worse was that in Guyana, we must always recognize our problems as leaders. We know in Guyana at election times, there are peculiar problems because of the ethnic voting patterns. We know also that there is a propensity sometimes for violence at election time. What we discovered in many areas, persons of one stronghold was taken from that, and the list for which those persons were to vote were located in a distant village, causing them to walk miles or travel miles into a different constituency to cast their ballots. Clearly intended to expose our atmosphere to unnecessary tension and possibly combustion, having regard to our history at election times and what is associated with that. Those were the things that we had to confront, so much so. 3 days before elections, there were a number of big areas where the people did not know where they were going to cast their ballots because GCOM was still not. We had to go with torchlight, floodlight into dark areas of villages on the East Coast to identify open spaces, because And we accepted their explanation. They don't want to go to houses. And we accepted that. The next alternative, if you don't have a public building, is a public space. So we had to go with torchlight and find playground and empty house lots. And then GCOM had to get tents and equip them overnight for people to go and vote there the next morning. And I say, without any fear of contradiction, as the leader of the opposition will say, the fear of successful contradiction, that there was a pattern. There was a pattern. And you know what the pattern was? Because we traveled both strongholds of the different political parties. Because the APNU AFC was part of that exercise, insisted that we go into areas such as Bachelor's Adventure, such as Victoria over the line, etc. And we went. And the position was not the same. They were not comparables. Only in the PPP perceived strongholds did we have these difficulties. So PPP electorates or supporters didn't know where they were going to cast their ballot 48 hours before elections day. These provisions intend to address that. Not to take away the power of the CEO, to circumscribe those powers, regulate those powers, insert into the law factors that he must take into account that before he chooses a polling station, and also there is a delimitation of numbers that can cast ballots at one polling station. So we don't have overcrowding. I have said repeatedly publicly, and I'm going to say it again. If anyone, and I've put out this challenge over a year now, and nobody has accepted it, and I hope that someone will try to do it tonight. If anyone can point to a single provision in these proposals which create an electoral advantage for the PPP, I am prepared to stand up here and debate it. Rather, for any political party. The point I want to emphasize is that any single person who is concerned about free, transparent, and accountable elections in this country will support every single amendment here, because they are all designed to bring clarity, to bring transparency, to bring accountability to the electoral machinery. That is all. Examine them one by one. I can go through. I may not have the time, but they are all here. So let me go to the bill itself now. So Clause 6 is amended, and that deals with the establishment of polling station. It says where no public building is available to be appointed, the chief elections officer may rent a separate private building unconnected with a political party or politician and appointed a polling place. How can you have a problem with that? How can you have a problem with that? A large polling place with adequate space may be divided into polling stations. No more than 400 electors to vote at a polling station. How can you have a problem with that? How can you have a problem with that? Factors to be considered in dividing a polling place into polling stations include, this is the circumscription or regulation of the discretion that I'm speaking about. 1, the number of electors on the list. 2, the size of the polling place. 3, the availability of internal and external space in the polling place to accommodate electors lining up at reasonable distance apart. 4, the accessibility of the polling place for persons with disability. How can anyone find this objectionable? And also, the chief elections officer, later in the bill, is mandated to give notice X number of days, I believe 5 days, before polling day. He has to publish the list of polling stations for all to see. How can that be wrong? There's a provision, I believe, for last minute changes, but as far as possible, he has to publish the notice to poll, the list of polling stations in the official gazette for everyone to see. How can anyone concerned about transparent election find that in any way objectionable. Then, Mr. Speaker, we have the division of the polling districts into subdivisions. And this is a direct answer to Claremont Mingo shenaniganism. A direct response to him. There's no 2-3 ways about that. We have countries in the world where millions and millions of ballots are counted and results are declared within a matter of days, weeks sometimes, depending upon the number. We have a couple thousand ballots in Region 4 that took us from March to August to count and resolve. How much was the total ballots in Region 4? What was the total ballots in Region 4? A couple tens of thousands of ballots. About 160,000 thereabouts. About 200,000, I'm told. It took us 6 months to count that. It means, unfortunately, that we are unable to count 200,000 ballots properly, fairly, and in accordance with law. And that was on display at Ashmin's building, and the stories are now unfolding before the Commission of Inquiry to refresh our memories if it is becoming dull. So, we proposed Region 4 first, as that was the problem region, and no one can dispute. No one can dispute that that's where the problem arose. Then the opposition party said that we are singling out Region 4 because it is their stronghold. We rejected that because there was nothing to do with stronghold and weak hold. It was where the problem arose. But we consulted, and I believe the private sector commission and some other electoral body came to us and said, look, just to appear even-handed, and we are, just choose another 2 regions or another region that is considered a PPP stronghold and do the same thing. We are motivated by no sinister motive, and therefore we are unopposed to such a gesture if it can bring the opposition on board, because we want the opposition to embrace these changes. After all, whether I like it or not, you are the major opposition of the country. I don't know how long that will remain so, but you are a major player in the electoral equation, and therefore you must have a say. You have the support of a significant constituency in this country. So honorable members, what we did is what we were proposing originally for Region 4, we replicated it in Region 3, a known PPP stronghold, and in Region 6, a known PPP stronghold. So if there is any disadvantage by the subdivision, the PPP is suffering it more by 100%, because we have 2 and you have 1. That is the extent that we are going to satisfy the queries that you have raised. So Region 3, Mr. Speaker, is now divided into 3, and what we have done is not created unknown divisions. We use existing polling subdivisions within the polling districts. All of us who have done election work at election time would be familiar with the different regions and the polling subdivisions within the regions. All we have done is use those same boundary demarcation so that for GCOM, they will correspond with the existing electoral division system in their system. So there is not going to be much work for GCOM to do when they have to enforce this legislation. So Region 3 is divided, as it is now divided, but in poll district, It is now divided into Essequibo Island and River Subdistrict. That's one. 2, St. Lawrence, Cornelia Ida Subdistrict. And 3, Hague to Arabio Creek Subdistrict. Now, what this amendment seeks to do is to replicate the identical structure which exists in the polling districts and to put them in sub-polling districts now, whereby you will still have a returning officer, but in each polling sub-district, you will have a supernumerary returning officer who, for all intent and purpose, will perform the very function that the returning officer would have performed for the entire region. So in Region 3, you will now have 3 tabulations being done instead of a tabulation being done in a central place. Each of these sub-districts will be tabulating their votes, and they will be sending their documents straight on to the elections, and all of that is outlined to the CEO, to the chairman of the election, because we amplify the persons whom documents have to send to, so that no one person will hold election documents at a ransom anymore. And we'll also send it to the RO, and the RO at the end, of course, they will have to tabulate. The supernumerary returning officer will tabulate in the same way that the RO tabulated, allowing all election agents, the observers, etc., to participate. We specify how he must tabulate. No breadsheet and spreadsheet, but he must use the statements of poll. He can project it on an electronic mechanism if he wishes, but the basis of the tabulation must be the statement of poll and nothing but the statement of poll. If there is any transposition from the statement of poll, then it must be done in a transparent way and with the concurrence of all the participants in the process, the statutory participants, and they are listed there. And these aggregates of these totals will then send to the RO, who shall declare. These regions, these supernumerary councils also, they shall, supernumerary returning officer also shall declare. The RO shall declare as well. So we have, and then, but I'm going to deal with that later. So that is Region 3. Region 4 is East Bank Subdistrict, North Georgetown Subdistrict, South Georgetown Subdistrict, East Coast Demerara Subdistrict. And Region 6 shall be East Bank Berbice, the Kanji Subdistrict, Upper Quarantine Subdistrict, and Lower Quarantine Subdistrict. Right? So I hope that you understand what will happen there. Now the SOPs are going to be sent to the CEO and to the ROs and to the chairman of the commission. The ROs, upon receipt, must post on the website. Must post on the website. If the RO fails to do that, and he must do it upon receipt. So within 24 hours, all the SOPs should be on a website. Then the CEO, if there's a default on the RO, must also post to the website. So within 24 hours, all the results are known in the country. And of course, with the various duties that are being created here, if there is any breach of these duties, serious criminal offenses are created and high fines and high term of imprisonment are imposed. Disciplined forces, when the disciplined forces cast their ballots, then it is inked and that it's crossed off, and that list is put into the ballot box and sent to the polling place where that person was registered to vote. So that's the guard against voters impersonation. We clarify the position of identity papers, and it's now stated what is acceptable as a form of ID. A valid passport is now acceptable. Any person who refuses to allow a voter to vote when that voter presents a valid ID is also liable to some serious offenses. Any person who impersonates a voter is subject to a number of offenses as well. Anyone who obstructs voting day activities shall be liable for a series of offenses, etc. Then, of course, we deal with how the votes are totaled. Clearly, at the polling stations, the amendments set out how the votes are to be counted, who are to be present, how the presiding officer must listen to the queries from the various persons and must sign off only when there is a consensus. Very transparent process of counting. And then when the count is finished, of course, like what exists now, the results, a statement of poll is posted there at a conspicuous part of the polling place. Anyone who removes that statement of poll also commits a serious offense. Mr. Speaker, also we deal with post-tabulation now and with the declaration of the results. And clear directions and guidelines are now set out to allow, well, rather to guide the Chief Elections Officer on how to compute the results and how to aggregate and what he must count as valid votes and what will be the total results, which he will do in accordance with Section 96 to pass over to the Elections Commission for those to be the basis upon which the election results, the Election Commission will declare the results. Mr. Speaker, we have also mandated the CEO a time period once he is in receipt of all the aggregate numbers from the various regions. He has 12 hours to compute his results in accordance with Section 96.
Honorable AG, as we are on time, you will need an extension of time to continue.
Thank you, Mr. Speaker. I'd like to ask that my colleague be given 5 minutes to conclude, please.
Thank you, Honorable AG.
Thank you, Mr. Speaker. Mr. Speaker, he has 12 hours from the receipt of the documents and the numbers to calculate and give to the Election Commission. So he will not be operating, as the CCJ said, what was the word they used? They use a Western word in them cowboy movie. What was it? I can't remember. Yes, he was a lone wolf or something like that. Yes. Lone Ranger. That was it. I remember. Thank you, Mr. Ramsey. He's not a lone ranger and he doesn't operate on his own time frame. He now has a statutory mandate. And Mr. Speaker, there is a fine of $10 million and imprisonment for 10 years for breach of these obligations. Mr. Speaker, the Election Commission publishes manuals, and I have no doubt that they do so with utmost bona fides to guide their election staff on election day on how to perform their respective functions. What we have found, and all electioneers in this house will agree with me, that on election day, sometimes when push comes to shove, crunch time, you have to argue with a presiding officer or some junior staff in the machinery about what the manual says or how the manual is being misinterpreted. Most times, Mr. Speaker, well, on every occasion, the manual ought to be in conformity with ROPA, the statutory code by which elections are conducted in this country. Sometimes the manuals collide with ROPA, or sometimes they contravene ROPA. But to convince a junior staff on election day of that is an impossibility. They are following that guideline, that manual, like a Bible, and that can lead to problems. When you try to get onto a CEO or an RO, you have great difficulties. What we are stipulating now as a matter of law, that any manual that GCOM wishes to use, and they have the autonomy to use any number of manuals that they wish, they must make them public at a period of 30 days after proclamation. 30 days before election day, they must make those manuals public so that they cannot change them after making them public. So that we have the time, all political parties have the time to scrutinize those manuals and find objections to them. Mr. Speaker, I am sorry that I have had to hurry my presentation. As I said, it is impossible for one to cover the breadth and width of the amplitude and gravity and magnitude of the menu of proposals that are here. They are wide-ranging. I know that there are many speakers after me who will speak, competent, experienced politicians in the election field, and I have no doubt, Mr. Speaker, that they will carry the baton on and further explain the various facets and tenets of this bill. Mr. Speaker, this is a good piece of lawmaking which every sensible Guyanese should throw their full support behind. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Attorney General. Our next contributor is the Honorable Member, Ms. Amanza Walton Dizu. Okay. Just before the Honorable Member starts her contribution, I would like to call on the Honorable Minister of Parliamentary Affairs to move the suspension of the standing order so that we can continue with this sitting to the end of the business of the sitting.
Speaker, I'd like to move the standing order to allow for the sitting to continue until the conclusion of the order paper today.
Thank you, honorable members. The motion is moved. Those in favor? Those against? Ayes have it. We are going to go beyond the 8 o'clock hour and to conclude when the business of today's sitting is done. Honorable member, you may now make your contribution.
Thank you, Mr. Speaker. Mr. Speaker, I wonder why is it that before I've gotten a word in edgewise, the honorable member seeks to distract. And that's a good thing. Predictability is a very, very good thing when it comes to governance. But you wouldn't know that, would you? Anyway, Mr. Speaker, I want to thank you for the opportunity to make my presentation to the Honorable House on this bill before us for consideration. It is absolutely important, and I have to agree with the Honorable Attorney General. He went into great depth and took great pains to point out that this is indeed a matter of gravity. In fact, Mr. Speaker, the Representation of the People's Act is intituled as an act to make provision for the election of members of the National Assembly under a system of proportional representation and for purposes connected therewith. I agree with the Honorable Attorney General that this bill is indeed a very weighty one. I noted that he indicated that he could not, at this time, go through in detail the provisions as set out. I want to propose to the Honorable Attorney General that given how grave and important this is, that the place for us as members of parliament, that the place for us as representatives of the people is to take this bill, you're absolutely right, to a select committee where we can clause by clause peruse the amendments that are being proposed. To quote the Honorable Attorney General, Mr. Speaker, who with an interest in free and fair elections, and who with an interest in law and order would oppose this honorable house sending this bill to a select committee so that we can peruse these amendments one by one to understand and to get clarification from the Attorney General for the rationale, sir, for the proposals contained herein. Mr. Speaker, the AG himself, the honorable member, pointed out that it is 63 pages in length and the amendments are wide-ranging. Mr. Speaker, I doubt that a responsible assembly would seek to, tonight, in the dead of night, foist upon the people of Guyana, sir, a bill that has not had the scrutiny of the select committee, bearing in mind the importance that the Attorney General has outlined that it has. Mr. Speaker, the Attorney General referred to a number of the main policies of the bill. And what I want to say to us tonight, and I said it on the last occasion that I stood here, is that the PPPC conveniently remembers history. The PPPC, in the person of the Attorney General, has come here to say to us that the reason for these amendments is what happened in 2020. Again, Mr. Speaker, operating as if Guyana's history began in 2015 to 2020. And Mr. Speaker, I want to say that and caution us that we really should not, as a responsible assembly, ram these amendments down the throats of the people of Guyana using their one-seat majority. The Honorable Attorney General himself said and acknowledged that we on this side of the House represent a significant proportion of the people of Guyana. And should the Attorney General be interested in fairness, I do not think that he will want to go on record as denying what he has said to be a significant proportion of Guyanese the opportunity to have their representatives, now that a bill has been presented to us, to peruse these amendments section by section. Anyone interested in law and order and democracy and all of the other tenets that you have said will not, sir, will not resist such a call. Mr. Speaker, the Representation of the People's Act, as admitted by the Honorable Attorney General, touches and concerns the entire legal framework for elections. It directly impacts a number of pieces of legislation, Mr. Speaker, and it is important that as representatives of the people, we be given the opportunity to provision by provision peruse these proposed amendments to make sure that we are satisfied with what is being proposed by the government. The Attorney General does not get to come here.
Honorable members, I was able to listen to the Attorney General. I would like to listen to the Honorable Member now presenting. Go ahead, Honorable Member.
Mr. Speaker, I thank you for that. Mr. Speaker, we on this side of the House will say that we support electoral reform. unequivocally. We support meaningful, we support honest and earnest electoral reform. Let the record show. What we will not support, Mr. Speaker, is the PPPC administration coming to this honorable house, like I said before, to foist these provisions upon the people of Guyana. Mr. Speaker, the honorable members on the other side of the house must know that public consultation and scrutiny of a piece of legislation by a select committee are two completely different things. So, Mr. Speaker, let them not come with that excuse. Mr. Speaker, I want to say this, because my task tonight before us is to examine the context within which these amendments are proposed. And just like the Attorney General, I have colleagues who will speak after me who will competently acquit themselves of the various aspects of the bill. Mr. Speaker, we can predict with certainty what will be said here tonight. Just like the Attorney General started with the 2020 elections and Mingo and all of these things. Mr. Speaker, I want to say this. We know that this is nothing short of gimmickry. Mr. Speaker, the PPPC administration knows that as at today's date, any talk from them about democracy, about transparency, about good governance is simply that, talk. Mr. Speaker, the people of Guyana have had 2 years to see and to assess the PPPC administration. And Mr. Speaker, I will say today that the people of Guyana have seen that this country, Mr. Speaker, that this country is in a state of democratic backslide, the likes of which we have never seen before. Mr. Speaker, the guardrails of our democracy are so brazenly and so wantonly being eroded, Mr. Speaker. Brazenly and wantonly. And Mr. Speaker, when we talk about democracy, the PPP wants us to pretend as if they are the bastions of democracy. When if we recall, Mr. Speaker, even the so-called branded guardians of democracy have parted company with them and are now openly critical of their corruption, their greed, and their avarice. Mr. Speaker, I am addressing before us the context in which the PPPC is seeking to move these amendments. Mr. Speaker, they have come into this house with the hopes that they can rally the people of Guyana to support them with cries of bingo and who rigged and who didn't rig. Mr. Speaker, and they're doing it with the sole aim of distracting from their mismanagement of the economy. They are doing it with the sole aim of distracting from their inability to bring relief to the poor and working class Guyanese. Mr. Speaker, the lived reality of the people of Guyana today is blackout multiple times a day. Dirty water coming through their taps, if any water at all. And the average man struggling to put food. This is the context in which, Mr. Speaker, the PPPC is coming today to ram these amendments down our throats. Mr. Speaker, let me say that, they can scream and detract all they want, but it does not take away from the lived reality of Guyanese. Mr. Speaker, I want to address our minds to the theoretical underpinnings of what is being brought here before us. I anticipate, Mr. Speaker, that from the array of speakers we will hear ad nauseum about the 2020 elections and the threat to democracy and all of that. Mr. Speaker, the truth is that for decades now, the call has been clarion for electoral reform, both by international observers and by Guyanese and civil society. Mr. Speaker, these calls were not born out of thin air. Events happened. Events before March 2020. Mr. Speaker, we remember in 2011 when the then CEO presented to the Commission the allocation of seats, you purportedly arrived at using a formula that he never presented to the Commission, but he arrived at a result. Mr. Speaker, we remember that. Thankfully, Mr. Vincent Alexander caught him in the act. Mr. Speaker, Guyanese remember in 2006 when the same CEO announced a result, sir, that was not in keeping with the votes cast and resulted in the AFC in Region 10 being denied their rightful seat. Mr. Speaker, we remember in 1997 when the then chairperson left a meeting of the commissioners, went, swore in the late Mrs. Jagan as president, unbeknownst to the rest of the commissioner. And our history records, Mr. Speaker, the throwing over of the writ over your shoulder, the greatest act of judicial disrespect that we have ever seen as Guyanese. Mr. Speaker, so the PPP doesn't get to come in here tonight to pretend to be the morality police. They don't get to come in here tonight to be the morality police. And Mr. Speaker, I make this point to say that as a House, we have two options. We can come here and we can continue to point the finger, or we can get down to what the people of Guyana deserve: proper, meaningful electoral reform. And Mr. Speaker, what that does not look like is what the PPP is purporting to do here tonight. Bring amendments. Use the tyranny of your one-seat majority to foist it on the people of Guyana. That is not what meaningful electoral reform looks like. So, Mr. Speaker, we have to be serious about what we're doing. I want to say that I sat and I heard the Honorable Attorney General go through the raft of promises that they have delivered to the people of Guyana, and he has named this as one such. On the last occasion I was here, Mr. Speaker, standing in this very spot, I spoke about the quality of the legislative enactments that we are purporting. Mr. Speaker, it is not about ticking promises. It is also about qualitative elements of what we are doing. And Mr. Speaker, I am submitting to us tonight that there is no way in one night we can go through and assess the quality of this bill in this session, Mr. Speaker. It needs to go to a select committee. Mr. Speaker, I want to say that the government, for all intents and purposes, Mr. Speaker, is not serious about electoral reform. They're not serious. And their attitude, Mr. Speaker, says to us that they have no intention of getting down to real, meaningful reform. Mr. Speaker, very, very important to this issue of electoral reform. Bearing in mind, sir, I will say that the IRI recently concluded a poll which showed that 38% of the people of Guyana did not believe that the results reflected the will of the people. And 81% of the people of Guyana want electoral reform. And I am submitting to us tonight that that does not look like the PPP coming to ram down our throats these amendments. Mr. Speaker, I want to look at a few elements of the bill in terms of the context within which this bill is brought, Mr. Speaker. Mr. Speaker, when we look at the issue of fines and penalties that the Honorable Attorney General addressed here tonight, we note, Mr. Speaker, the very draconian, sir, fines and penalties that have been placed in this bill. Mr. Speaker, these are matters that ought to be properly discussed. Because, Mr. Speaker, not only us on this side of the House have raised the objection, noting, sir, that what this does is deter qualified, competent people from participating and working with GCOM to administer our elections. Mr. Speaker, the honorable members on the other side of the House can heckle, they can say whatever they want to say. It does not change the reality that the fact is that this will serve to deter qualified, competent people from being employed with GCOM. Mr. Speaker, I'm finding it very difficult to rationalize the draconian penalties in view of this particular fact. We are driving away qualified people, Mr. Speaker. Why would a qualified person want to work with GCOM? If it is a case where a genuine, for example, mistake is made and they're facing draconian fines and penalties, unless, Mr. Speaker, that is the intention. One must wonder, is the intention to dissuade competent, qualified people from manning our election system so that it could be stacked? So that it could be stacked with persons favorable to the PPPC administration. One must ask the question, Mr. Speaker, and just so that we know that this is not conjecture, they must tell you that they objected to 72 persons. 72 persons who were appointed to be officials at the upcoming LG. They wrote objecting to those persons, to the CEO. And you know what the CEO responded to say to them? Listen to me, if you are going to object to these people, we already have such a challenge with manpower that the LGE will not be able to come off at the time that you want it to come off by. They must tell you that. So, Mr. Speaker, this is not about conjecture. Mr. Speaker, this is a live situation that is happening right now. Right now, as a result of these proposed amendments. Mr. Speaker, we have to ask the question whether this is the motive. Mr. Speaker, you know, it doesn't strain credulity that the PPP would want to stack the system with people that they view as their people. Mr. Speaker, they will be, as the government, in a position to offer persons that support them the protections from the type of prosecution they are prescribing here in law. In other words, man, you do your thing. We got you covered. Mr. Speaker, it does not strain credulity when the PPPC has demonstrated their willingness and their ability, sir, to shelter their agents who are involved in wrongdoing. Mr. Speaker, in my own portfolio, I am thinking now of our High Commissioner to India, Mr. Speaker, who for all intents and purposes unleashed the vilest of attacks against a female in India, and he is still sitting comfortably as our High Commissioner. So, Mr. Speaker, they have demonstrated this ability to protect their people who are involved in wrongdoing. So they're going to tell them, y'all go, we got you covered. We will not allow you to be charged. That is the motive, Mr. Speaker. That is the motive. That is the motive. Let us not fool ourselves, Mr. Speaker. They want to stack the system with their people. Mr. Speaker, I want to say that, thank you for recognizing that I am a special talent, Honorable Member Nandlal. But I will say this, that we on this side of the House, in taking up what the Attorney General has said, are not opposed to electoral reform. We are willing to support the amendments as long as we are satisfied that they meet the criteria, that the rationale is sound. And Mr. Speaker, I am repeating here that we will be able to do that in a select committee, sitting with the government and reviewing these provisions one by one and bringing it back to this Honorable House to say that this is an effort that we have made collectively. Mr. Speaker, the point that I want to make Mr. Speaker, I can't help but be amused by the Attorney General's statement that I have not made one comment on the bill. I'm not sure. Well, anyway, he left the room, so he must not have been following. Mr. Speaker, in excess of 46 amendments, and the Honorable Attorney General has indicated that he will not be able to go through all tonight, but is trying to take me to task for not rushing. Mr. Speaker and Honorable Member Nandlal, this is my 30 minutes, and therefore I will say what I want to say on the bill. You will not prescribe what I say. Mr. Speaker, the final point that I want to make in terms of the context within which this bill is brought is that, as noted by the Honorable Attorney General, there are a number of interrelations with other pieces of legislation. One we will consider here tonight, Mr. Speaker, the National Registration Amendment Bill, Mr. Speaker. The electoral laws, Mr. Speaker. There is a Webster of provisions, and we are not satisfied on this side of the House that they have been able to be properly and thoroughly reconciled. My suggestion, as the Honorable Member and the other House has asked, is for us to take this to a select committee so that we can review it. Anyone interested in transparency and democracy will not object to that. Mr. Speaker, I want to turn our attention to Part 4A, the preparation of the official list. And I will give you, for example, Mr. Speaker, one concern that we have on this side of the House that we believe has not been properly ventilated in terms of the rationale. Mr. Speaker, if the Commission so directs by order, notwithstanding anything contained in any other written law, the electors to choose the members of any local democratic organ other than a regional democratic council or other local government authority shall consist of names extracted from the official list of electors under this section and registered with an address of the local democratic organ or local government authority. Mr. Speaker, the Honorable Attorney General went into detail to speak, well, not detail, he mentioned in passing the issue of residency. Mr. Speaker, we believe that this is a matter that requires much more thorough interrogation to come to a position that is progressive and that is responsive to the reality on the ground, Mr. Speaker. That is what we truly believe. And so we are asking, Mr. Speaker, and my colleague, the Honorable Shadow Attorney General, will speak to this in greater detail. Mr. Speaker, we want to examine Section 87 in terms of the context again. And the Honorable Attorney General mentioned the issue of the supernumerary officers. Mr. Speaker, the question arises as to the capacity of the system with these new manpower requirements that we are imposing. Mr. Speaker, how has that been studied out? What are the implications for GCOM? What are the implications for its operating costs, Mr. Speaker? These are all very pertinent and relevant issues that have to be considered. Mr. Speaker, the Honorable Attorney General mentioned as well, sir, the issue of premises for which polling stations must be located. Mr. Speaker, for example, we wish to recommend that the House considers, and this is something we can speak more to in a select committee, that the House considers perhaps giving parties the option of a no objection rather than leaving this to the chief elections officer. So for example, the opposition parties may say, look, we do not agree with this premises. We agree on this one. Mr. Speaker, that is an option that is not explicitly spelled out and should be explicitly spelled out. Mr. Speaker, the other issue that we want to look at in terms of the interrelated nature of this, Mr. Speaker, we want to look at two issues.
Before you look at the two issues, I'll need to give you some time.
Yeah. Could I ask that the member be given 5 minutes to conclude?
Go ahead, Honorable Member. 5 minutes to conclude.
Thank you, Mr. Speaker. Mr. Speaker, I have 5 more minutes, and in that time, I wish to say to us here, sir, that these over 46 or so amendments require a thorough examination. Mr. Speaker, we will continue to repeat on this side of the House that we require, as the representatives of 49% of the population, as the Honorable AG stated, that this bill go to a select committee so that we can review it. Mr. Speaker, I will say that this issue of consultation and public consultation is a different matter from when a bill comes into this House, that it should invoke the parliamentary procedure of being sent to the select committee. Mr. Speaker, in wrapping up, I want to say this, that we have to be serious, and we have to be serious in this House about electoral reform, Mr. Speaker. Mr. Speaker, we are standing here and we are talking about this wide and sweeping ROPA. And Mr. Speaker, they are low-hanging fruits that we can pick, Mr. Speaker, to demonstrate to the people of Guyana that we are really interested in free, fair, and transparent elections. Mr. Speaker, this issue of biometrics at the place of poll, any person, Mr. Speaker, interested in free and fair elections, why would they, to use the Honorable Attorney General's words, why would they, sir, reject this issue of biometrics at the polls. Mr. Speaker, they are saying, oh, it precludes people from voting, when the truth of the matter is, Mr. Speaker, all that it is doing is confirming that you are who you say you are. Which person interested in transparency and in fairness, Mr. Speaker, will resist that? Mr. Speaker, one other observation, and this is in the context in which this bill is brought. Mr. Speaker, I note that there is a hearkening back, Mr. Speaker, to the 2001 list or the 2001 database. And given that these matters are interrelated, sir, I wonder whether the AG can make clear here tonight why we are not referring to the 2008 database that was created, sir, out of that house-to-house exercise. Mr. Speaker, to quote a document from GCOM, it says the imperative to conduct the 2008 house-to-house registration exercise was born out of the need for the creation of an indisputable national register of registrants, which could be used as the basis for the preparation of electoral lists that would be commonly acceptable by all stakeholders as being unblemished. Mr. Speaker, when taken together, this act and the amendments to the NRA seeks to bypass that 2008 NRR that was created to refer us back to a 2001 NRR, Mr. Speaker. Mr. Speaker, it appears to me that the result of that would be to disavow that 2008 NRR, harken back to 2001, Mr. Speaker, and what the intention is, I am presuming, is by the operation of the law to allow for people who did not present themselves in 2008 to be registered to somehow be brought back in through the back door. The result of which, Mr. Speaker, if we continue on this trajectory, would be that Guyana will soon have a voters list that exceeds its population if we continue on this route, Mr. Speaker. It cannot be that in a democratic society, we are going to say to the people of Guyana that our hands are tied, that dead people who have died overseas, whose deaths have not been registered here in Guyana, must remain on a list, must provide an opportunity for mischief, and we in this honorable house can do nothing about it. Mr. Speaker, that is an unacceptable position for us to put to the people of Guyana. Mr. Speaker, what I have attempted to highlight here tonight is that this matter is a complex and far-reaching one, Mr. Speaker, and the people of Guyana are far more deserving of proper review and not a 3-hour debate in which we will come, trade words, and they will foist down the throats of the Guyanese people. A sham of an attempt at electoral reform when the people of Guyana deserve deep, meaningful reform, Mr. Speaker, to curb this current trajectory of democratic backslide on which we find ourselves. Mr. Speaker, I thank you for affording me the opportunity.
Thank you very much, Honorable Member. And now for the Honorable Minister of Home Affairs, Brinley Horatio Ben.
Thank you, Mr. Speaker. Mr. Speaker, it's really difficult and still somehow traumatizing to hear the honorable member who just spoke before me go through a presentation which basically suggests that the APNU-AFC has no real interest in electoral reform, in dealing with the questions which we have experienced, which we have suffered by in relation to the questions of elections in Guyana. The subversion of our democracy, the criminal acts which were perpetrated in relation to the elections, as recent as the 2020 elections, but in fact which go several cycles, several decades, several elections periods, where they, in the form of the PNC, and later the APNU, and now the AP and the AFC have been involved in elections rigging in Guyana and subverting the democracy of our people and stealing the will and the votes of our people. It is indeed a tragedy that such a younger person, educated, erudite, but irrational, are not paying attention to the facts of the matter and the historical reality and experience of the Guyanese people in elections. It's really, really a tragedy. And the fact that she has been put as the lead, the first speaker on that side, in respect of this matter, ahead of other persons, ahead of the Rambuttans and the others, and some who are not here, ahead of Ms. Walda Lawrence, to present on this matter speaks to the continuing insidiousness of this political party, the APNU AFC, on that side of the House, in respect of continuing to undertake acts, to undertake stratagems in relation to continue to undermine, to suborn, to destroy our democracy and the peace, the security, the goodwill, and the proper living together, the coming together of the Guyanese people. The problem of elections is the one which, whether you say it is ethnic voting, whatever kind of voting or whatever, is the problem where advantage has been taken of ethnic differences and other differences to hold on to perceived vote banks, to hold on to enclaves, to hold on to persons who are kept in thrall, who are kept captive by political messaging of a negative form, merely for the position, merely for the intent of holding on or attaining political power, wrongfully. The AP and UAFC in this House, even though the member before me, honorable member, Ms. Desi, who spoke before me, said that they were somehow in support of electoral reform. The AP and UAFC in this House and in this place owe the Guyanese people an apology. Yes. Owe the Guyanese people an apology. And I thought that in putting the young lady to make the presentation without resorting to the other known acolytes in respect of electoral malfeasance, I had hoped that the young lady would have been the one to proffer the apology to the Guyanese people, and that we would have been able to take a new path, take responsibility with respect, following introspection, retrospection, take account of our failures perhaps in respect of these matters, and let us go forward to a new plane, accepting what should be for our people, for the future of the people, for our country. Now we are at the most propitious moment in our economic and social and hopefully political development. And so the presentation just now, in the context of what is intended in this representation of the People Amendment Bill, is disgraceful. It's disgraceful. It is disgraceful. And I am deeply disappointed. I am deeply disappointed that the young lady would have been allowed to and would have enjoyed the moment in deflecting, avoiding, and taking account of the real need and resort here in this amendment bill to fix issues which were clearly not properly operated on or which had to be dealt with in relation to the most recent experiences in elections. Do I continue to say that we had problems in 2015? Of course, there were boxes which should have been opened and counted, 20 odd boxes, 21 boxes. There were issues, as usual, with voter suppression, which were talked about. There were issues in relation to preventing people from getting to vote. There were issues of people being threatened and locked out of places. You either couldn't come out of the box or you were threatened, and there were people going around with guns threatening polling agents in 2015, and even before that in 2011. There's a long list of what are crimes in relation to the question of assuring the free and democratic will of the Guyanese people in voting to elect a government to represent the people of their choice. The honourable member speaks to going to a select committee. I am aware that there was widespread national consultation on this matter. I am aware in this very place that the opportunity was afforded for consultation with the political parties, either as groupings or individually. I am aware that there was a walkout in respect of this matter too by the honorable member who just spoke before me, amongst other persons. Walked out on the question of the consultation on this document. And now, coming here, having had over a year, and then the specific forum, the specific engagement to have the clause by clause consultation on the matter in a public forum, walked out and now coming here to say you want to go to a select committee. Insincere, of course, natural for the AP and the AFC, and I have to say this insincerity is a trademark of theirs, along with the willingness, the intent, and the interest to always take illegal resorts to undertake fraudulent measures in respect of elections. It's in their DNA. It's in their DNA. It can't be changed. They will always attempt fraud at elections in Guyana. Always. The rigors by nature. And it cannot be changed. And the fact that you have a Ramjatan and some others who have recently joined up with them will not change it. And the fact that persons who were participants, willing participants in the great fraudulent 2020 elections exercise can sit here unashamedly and enjoy this debate speaks volumes as to their nature, their intents, and their continued willingness to continue fraudulent resorts in respect of elections in Guyana. The honourable member before me talked about that there is no real interest in the working class people, that there is no real intent in working class people, no real interest rather, and that this engagement is merely a talk, and this document is a gimmick. And every time they've had the opportunity, particularly from 2019, I believe, in respect of the NRR, in respect of the appointment of the GCOM chair in the form of a Mr. Patterson, and all the stages, all the efforts which are made at the courts to change the undertakings they did in respect of the electoral laws and the proper conduct of elections, they lost in the courts. They lost in the courts. And in spite of all of that, not only in Guyana, but at the CCJ, the apex court, they lost. In spite of all of that, a young trained Guyanese lawyer would be the first speaker here to speak on this matter and to say that this document, the changes, the amendments in this document, which are clearly intended to protect the electoral system, the machinery from malfeasance, continued malfeasance, from distortions, from any issue, preventing any issue which will thwart the will of the Guyanese people, and which were given by repeated examples from the presentation of the Honorable Attorney General. They would come here and say that this is gimmickry, this is not useful of itself, and really should go to a select committee where I expect there will be great time wasting and, in fact, would bring us into problems in relation to the holding of the local government elections. In fact, I don't think they want to hold local. I don't think they want to partake in local government elections. They don't want local government elections. They only like elections when they can corrupt it, frighten people, terrorize people, conduct fraud, bully people, chase people out, beat people. That is when they like and want elections. It's historical, it's documented. It's historical and documented. And so I think fundamentally that this document gives us the information, the results, the platform to move to a new and better stage in relation to the conduct of elections in Guyana. That the members on the other side would gladly embrace the amendments in this document in relation to the conduct of polls, in relation to the provision of the supernumerary officers, in relation to the placement of polling stations, in relation to, of course, what were termed draconian fees, fines, and imprisonment in relation to misconduct by persons who are appointed to conduct the elections according to the spirit, letter, and intent of the Representation of the People Act and the Constitution of Guyana. There's a suggestion that it may deter some people from wanting to become elections officials. If it deters anyone, it would be those persons who would have either the subliminal message or the distinct intent, or would have been placed to conduct the elections in an improper way. And so, what is termed draconian in terms of the fines and imprisonment is appropriate to bring this great disgrace to an end, the question of electoral fraud in our country. It's disgraceful. It's disgraceful. And not only regionally, internationally. We were here 5 or whatever months, as was said, to count 200,000 or whatever number of votes. We had all kinds of shenanigans in relation to protecting the ballot boxes. The most distressing moment in Guyanese history over the last 3-4 years were that period, those moments. But I won't make it personal. I am not going to make it personal. Not now. I am not going to make it personal, no. But I would still have to thank, I would still have to thank Honorable Member Priya Manichan and Dr. Frank Anthony for coming to my aid and assistance while I was still out there. But I'm not going to make it personal. I never will. So the most important thing, totally and in context with this document, is for an open admission to be made by leading members of the APNU AFC to chart a new course, to accept wrongs which have been done, either in their name personally or as a grouping, and to recognize that what is required for the stability, the proper development of our country is to fix this problem. There are other problems which we should be paying more attention to. The question of the sovereignty on the western border, the question in our discussion in terms of the budget, in terms of making the most efficacious use of the monies for development, the question of how do we restore our agricultural sector, the mining sector, the bauxite people who suffered because the river was blocked, the Berbice River was blocked, the incredible imposts which were made on the life of the people by way of VAT and other imposts while they were in power. Those are the things we need at this moment to get past and to agree on a new approach as to how we will protect and develop our people. But unfortunately, the door is not closed, of course, but unfortunately, the first presentation which is made here does not help it. Does not help it. I would want to posit that in spite of course, in spite of the opportunity of making a long speech, but that we should spend more time, take the opportunity to go through it, the presentation and the review, clause by clause with the Honorable Attorney General, because of course it's 40 odd amendments, and it would not help for me necessarily to go speaking beyond what I've already said, given the seeming time constraint and the necessity to specifically identify the clauses here which need to be dealt with in committee. So with that, Mr. Speaker and honorable members, I fully support the amendments in this bill, fully support these amendments. I recommend it to the House. I see again, it provides us with the opportunity to gather around, put our minds together around the necessity for accepting and working with these amendments and making it work for our elections so that we could protect our democracy, so that we could protect our people as we go forward in the ennobling task of developing our country. The ennobling task of developing, bringing together a multiracial, multi-ethnic, multicultural, multi-religious country, remarkable for any other place in the world. The failures which we have had so far are resident in the changes which could be brought around by way of these amendments on the question of this democracy here in Guyana. And we have to acknowledge our collective failures on the matter. This document provides the opportunity to get around and get past and above these collective failures in respect of electoral democracy. And it is for that reason that I fully support and commend this bill from the PPPC in relation to further strengthening democracy, democratic culture and behavior in this our country, Guyana. Thank you very much.
Thank you very much, Honorable Minister of Home Affairs. And now for the Honorable Deputy Speaker, Mr. Lennox Schumann.
Mr. Speaker, can you hear me?
Yes.
Let me place firmly on record, in the unlikely event that we will have some technical difficulties, I want to place firmly on record that this bill enjoys my 100% support. It was only about 2 weeks ago, Mr. Speaker, that I testified before the Commission of Inquiry on Elections in Guyana. I have had to go through the very horrifying task of having to identify what transpired after the March 2nd polls closed and everything that ensued after voting and with Region 4. I have had to relive minute by minute all of the events that transpired. It is the first time in my life and in many other young people's lives that they would have had an opportunity to vote or to witness an election. And what the people would have seen would not be representative of what the future Guyana should have looked like. I remember some of my colleagues, when I say colleagues, I'm talking about opposition colleagues who were in the House, who were part and contributors to the possible theft of a nation. I remember very explicitly, Mr. Speaker, having to pick up the Honorable Robson Ben right at the back of the very chamber where Parliament is held now, after he was thrown over a rail. These things should not happen in a modern democracy. I am taken aback by my parliamentary colleague, Ms. Desir, on her presentation, speaking about sending a bill to committee. And the reality as it stands, Mr. Speaker, is that there are members in the opposition who want to send this to committee, who want to hinge it on constitutional reform and to tie the two of them together. But yet, in their quiet conversation, they have no intent, no appetite to support constitutional reform. So essentially, what my colleagues in the opposition want to do is to send this bill to committee so it can die a slow and painful death and have no reform executed on the electoral system. The reality, Mr. Speaker, is that having been a witness to what transpired post March 2nd, 2020, I will say that these reforms are desperately, desperately needed. The fact that you may not have requirements for biometrics at a polling station does not eliminate the possibility of that. Having so many lawyers on both sides of the House who are more amply qualified than I am in legal matters, they would know fully well that Article 163 gives the Guyana Elections Commission the authority to utilize whatever measures they have to ensure that the process is fair and transparent. What this bill does not do, it does not hamstring the Guyana Elections Commission from being innovative in how they conduct polls. It opens the door for the Guyana Elections Commission to now explore those possibilities. And I will say, Mr. Speaker, and I would rather be very short, very succinct, and to the point. There is no point in beating around the bush this bill does exactly what it needs to do to ensure that what transpired in 2020 never happens again. Mr. Speaker, that is where I rest my remarks. As I have said previously, time and time again, I would rather be very succinct and to the point, and this bill enjoys my 100% support. Thank you.
Thank you very much, Honorable Deputy Speaker. And now for the Honorable Member, Mr. Minister of Natural Resources, Mr. Vikram Bharat.
Thank you, Mr. Speaker. Mr. Speaker, I rise to make my contribution and to fully support the Representation of the People Amendment Bill, Bill number 24 of 2022. Mr. Speaker, it is very strange that any opposition, as a matter of fact, will not support amendments that would strengthen the electoral process in a country, when the very opposition is protesting every single day for some of the very measures that are placed in these amendments tonight. Mr. Speaker, every single amendment in this bill this evening is to strengthen the transparency, strengthen the fairness, strengthen the accountability, and ensure we have free and fair elections in Guyana. And if there is an opposition that is not prepared to read the bill and to debate it tonight, then we are in a sorry state as a country. Mr. Speaker, the opposition loves to speak about government using taxpayers' dollars. Mr. Speaker, if I may remind them and let the people of Guyana know that the very taxpayers' dollars are paying the opposition MPs as well. They are receiving taxpayers' dollars. They are enjoying unlimited duty-free concessions similar to us on this side of the government house. They are receiving similar benefits as member of parliament similar to us on this side of the house. So it is their duty to the people of Guyana to ensure that they come to this house prepared to debate such an important bill. Such an important bill, Mr. Speaker. So it is a very sad state and a sorry state when you have an opposition that is not willing and prepared to debate on such an important bill. But to use the easy part and said, let us take it to a special select committee. Mr. Speaker, I've been in the National Assembly since October 2016, when this very APNU AFC was in government. And I have seen them taking a number of bills to the Special Select Committee that are probably still somewhere in the Special Select Committee. We have never seen the daylight of some of those bills that they themselves took to the Special Select Committee. Mr. Speaker, it is just a ploy to delay the process. It is just a ploy to frustrate the work of the government. It is just a ploy to delay the local government elections 2023, which will obviously embarrass the opposition. Already, there are issues among themselves. So that is why they were not participating in the consultations that we had. Instead, they were busy dealing with divorces. The AFC divorcing APNU on the 31st of December. They're busy fighting who should be opposition leader and who should not be. They're busy rigging their own internal elections, as one member of parliament who unfortunately is not here for obvious wrongdoing, commented in the public that they're internal rigging. So, Mr. Speaker, how can you trust an opposition where their own internal issues with election, they're rigging their own internal elections? How can they safeguard a national election? Mr. Speaker, 2020 is being used or being mentioned so casually, as if, it was no big thing. Mr. Speaker, that was an embarrassment to the people of this country. It was an embarrassment to this country as a whole, where many of their members were sanctioned. Many of their members, unfortunately, lost their visas as well too. But yet they come to the assembly and they behave as though 2020 was nothing where we should talk about. That we should just get moved past that. Mr. Speaker, we are probably one of the only countries in the world where we had an election on the 2nd of March 2020, and 5 months after, then we were able to swear in the next president. We had multiple court cases that were basically baseless. We had GCOM officials who compromised their position and their integrity to undermine the electoral process and democracy. And yet, we speak of 2020 as if nothing really happened. 2020 and the APNU AFC disgraced our country. They brought shame to the people of this country. So, Mr. Speaker, as I mentioned, this bill is necessary. This bill is necessary regardless. The amendment to this bill is necessary regardless that we have a very strong electoral system in our country. Regardless that we have a strong electoral system in our country. And we heard from the member that spoke from the opposition benches before the deputy speaker about the list. Mr. Speaker, let us remind them that this is the very list that they claim to won the 2015 elections with. But when they won in 2015, the list was good. The list was clean. The list was perfect. But when they lost in 2020, oh, it is a bloated list. The list is padded. Dead people voted. And all sorts of excuses we're hearing from them today. But it is the very list. It is the very list that they won the election in 2015 with, that we contested the 2020 election. Now we hear about election petition, we hear about court cases, we hear about bloated lists, we hear that the PUP is not interested in biometrics. The PUP have never said that. The People's Progressive Party of Civic have never said that we are against biometrics. What we have said is that it must be used to complement the existing system that exists right now. It should not replace the existing system, but it could be used to complement the system, to put further safeguards to our electoral process and the verification of voters on election day. Mr. Speaker, it was mentioned that we only speak of 2020, but maybe we should go beyond sometimes. We go back. Mr. Ramjitan said that Guyana started in 2015. But we know what happened in the past post-independence. We know what happened post-independence. 1968 elections, rigged. 1973 elections, rigged. 1998 elections, rigged. 1985 elections, rigged by the PNC. Imagine in 1973, the PNC claimed that they won 70.1% of the votes. In 1980, 77.66% of the votes. In 1985, the PNC claimed that they won 78.4% of the votes. Imagine that, Mr. Speaker. Imagine that, Mr. Speaker. And then they come to this house and talk about democracy. And talk about democracy and how our democracy is being derailed. But, Mr. Speaker, we witnessed the biggest rigging ever in this hemisphere during those periods. And then when we finally got a free and fair election in 1992, the PNC moved from 78.24% to about 45%. To about 45%. From 1985 to 1992. Mr. Speaker, as I mentioned, we have a strong electoral system in Guyana. But we need to improve as time moves on. We need to ensure that people don't abuse, as the Attorney General said, abuse their discretion, compromise their integrity, And that is what we saw in 2020. So these amendments seek to address those issues, seek to address the abuse of authority, abuse of their office, abuse of their power, and abuse of the discretion that is given to them, and to ensure that we legislate it, and people must follow the legislation and the laws, and ensure that there are strong penalties. It is very disheartening to hear an opposition member coming to this house, and the only recommendation or the only issue, relevant issue she could speak on was penalties are too tough. This is wrongdoing we are talking about, Mr. Speaker. You're rigging an election. It is fair enough for you to be fined $10 million and imprisoned for 10 years in jail. You're snatching the rights of every single Guyanese in this country. You're taking away our democratic right. You deserve even more than 10 years. Maybe the Attorney General was a bit easy or flexible. Mr. Speaker, there are a number of infractions, a number of inconsistency and abuse and compromise that we would have witnessed over the last few elections. Hence, our position today of bringing these amendments to the House. And one such infraction, I'll go through a few, Mr. Speaker. One deals with tender ballots. Tender ballots. Mr. Speaker, for the Guyanese people who are looking at this live broadcast, they're ordinary ballots and they're tendered ballots. And Mr. Speaker, it is of two different colors. It is of two different colors. But yet we had instances, right on the East Bank, where I worked in 2011, where a presiding officer issued 19 tendered ballots to voters who properly identify themselves, who are eligible to vote, who are on the list, but yet they were given tendered ballots. And Mr. Speaker, we know that the law states that tendered ballots is basically an appeasing ballot paper. It is only used when somebody comes to the polling station and they claim that they didn't vote, but their indication, and it is verified by the presiding officer, but that they would have voted. But because they're behaving unruly and disorderly, a tendered ballot is issued to appease them. But it is not counted. It is not counted. So because of that, 19 voters in Horstellian in 2011 lost their right to choose a political party to govern this country, even though they did nothing wrong. Even though they did nothing wrong. Mr. Speaker, it might sound very simple, but this amendment, one of the amendments listed here, is to correct this injustice that was done to the electors in Horstellian and many other areas across the country. Across the country. And every single election, if you add or total up the amount of tendered ballots that are issued to legitimate voters, it is probably in the thousands, Mr. Speaker. It's probably in the thousands. Mr. Speaker, moving on. We had similar instances in many polling stations where presiding officers issue ballot papers to voters without stamping it, without stamping the ballot paper. Mr. Speaker, based on the counting procedure and our laws, once a ballot paper is not stamped, then it is not valid. It cannot be counted. So, Mr. Speaker, we are correcting all these wrongs that has been part of the electoral process over a number of years. Another such infraction, Mr. Speaker, and which we are amending here, is misinformation given to voters by GCOM staff. And in some time, I think was 2006 or 2001, when they introduced what we call information officers. These are officers, 2011, sorry. These are information officers who sit at the gate or the entrance of a polling place. A polling place will carry more than one polling stations. And they will misinform, in some cases, willfully misinforming voters as to where they can vote and that their names are not listed on that particular list. There is a penalty for that, Mr. Speaker, because that is taking away the rights of people. And we know that once people are frustrated, and that is the purpose of doing that. Once people are frustrated, they don't go to a polling station, but they return home. And a vote is lost. Mr. Speaker, the issue of lists being given to polling counting agents on the morning of election. And this has been a big issue, and we have recognized this, and we have seen this during the recount, where we sat in this very building for 33 days to recount every single ballot cast in this country. And yet, the opposition mentioned 2020 as if it was nothing to worry about. Mr. Speaker, there were many instances where polling agents were given the list, and we know that they're normally given the OLE, the list of proxies, the list of disciplined services members who would have to vote. Those lists are given to the polling counting agent on the morning of election. And in most instances, at the close of poll, the presiding officer will tell the polling agents that they will have to collect back the list. We are changing that. It should not be based on the discretion. But we are amending it here to say that the lists given to the polling counting agents must be kept by the polling counting agents. And mind you, Mr. Speaker, that every single party will have a polling counting agent at every single polling station, depending on their ability to do that. So it is not favored or it is not designed to benefit any particular political party. More so, it is not designed to benefit the People's Progressive Party. It is designed to ensure that there is fairness among all the parties and that all the polling agents representing all the different parties are allowed to retain and keep their lists so that it becomes the property of their party in case of any disputes after that. Mr. Speaker, the list of proxies. The list of proxies, and this is very critical because this is one avenue that was used in those years of rig elections. It was abused in those years of rig election, where people were forced to sign proxy lists to give up their right to vote to the next person. So what we are doing, attempting to do here, Mr. Speaker, is to ensure that we put it into the law. To state that the list of proxies must be posted up on the polling station, outside of the polling station, before election day. So that if there is any objection, it can be taken into account. Mr. Speaker, how can this be an amendment that will work against anyone who wants a free and fair process? How can an amendment like this favor one political party only? It is amendments that will bring fairness to the process. It is an amendment that will bring fairness and transparency and ensure that there is a level playing field for all political parties. For all political parties, and not only the People's Progressive Party. Mr. Speaker, if we may, the Honorable Attorney General spoke on the tabulation, but if I may go a little beyond that, as to recount, requesting a recount. And we can recall that in 2015, when our counting agent in Georgetown, the Honorable Charles Ramson, as the counting agent, requested a recount, but we couldn't find the officer. We couldn't find the officer before 12 o'clock of the following day to submit that letter requesting a recount because the officer obviously went into hiding. So we are changing that now, Mr. Speaker. We are changing it that if we cannot find the RO for some reason or the other, or in some cases, the supernumerary returning officers, in the case of Region 3, 6, and 4, that the letter of recount can be served to the chairman as well as the CEO before 12 o'clock of the following day. And that is fair. What is wrong with that? What is unfair about that? What in that is giving the advantage to the People's Progressive Party? It applies to the opposition too. They can do the same. They can also serve a recount letter request to the chairman or to the CEO. So there is nothing in this, Mr. Speaker, as the opposition want to see, that is giving advantage to the People's Progressive Party. Because we have heard a lot about that. We have heard a lot that the People's Progressive Party is amending the Representation of People Act to favor them and to ensure that they stay in power. Mr. Speaker, we will stay in power because of our track record, because of the development that is taking place, because Guyana is the fastest growing economy in the world, because we are having new revenue stream every single day, the latest one being the sale of our carbon credits. So, Mr. Speaker, the opposition is obviously running scared, and they know that the writing is on the wall, that they will remain in the opposition benches for a number of years. So they're trying to clutch at every single straw. They're trying to clutch at every single straw, bringing out 2 or 3, 5, 6 persons to pick a GCOM every single day about bloated lists. The member said that we might have a list that is bigger than the population of Guyana. Mr. Speaker, if you look at some of the Caribbean islands, it is a common trend. It is a common trend in small populated countries where there's high migration rate, where people travel to work in different countries. But it is their democratic right to stay on the voters list once they're Guyanese. That is their right. We cannot take that away from them. That is their entitlement as a Guyanese. And as the Attorney General mentioned, they could live where they want to live. But because they're Guyanese, they're entitled to be registered and come home to vote. The APNU AFC is trying to take that away from Guyanese. That is undemocratic. That is undemocratic. So, Mr. Speaker, they're trying to clutch at every single straw. We made it clear on the biometrics issue. We heard tonight that the PUP is against that. We have never said that. We said that it must be used, or it can be used, to complement the existing system and to give more strength and robustness to the electoral process or the verification process. So, Mr. Speaker, there are many other infractions which we would have looked at, that people obviously have used their position, the office, and the authority to abuse and to favor political parties that they are aligned to. And we have seen that in 2020. We have seen a CEO trying to disenfranchise almost 180,000 voters in this country. And yet we talk about 2020 as if it was nothing. But we had a CEO who was trying to say that 180-something thousand votes is not valid. And by what means? What was the criteria used? Only he knows. And the people who you were trying to put into office or to keep into office. Mr. Speaker, in the past, we have always heard this complaint from our polling agents, that one, the presiding officer don't want to give them a statement of poll. That is illegal. And we have enforced it in this amendment here, Mr. Speaker, that every single polling counting agent must be given a signed, correct copy of the statement of poll. A signed, correct copy of the statement of poll. And it is an offense, there is a fine, and there is jail time to it, Mr. Speaker. Another complaint that we've heard many times is the GCOM officers telling polling agents. And Mr. Speaker, when I say polling agents, I mean agents representing all political parties, not only the People's Progressive Party. GCOM staff saying to polling agents that we don't have space in our vehicle for you to accompany the ballot box. And it is based on their discretion how much they can take, how much persons they can take, and who they want to take. We are seeking to change that in this amendment, to say that they must be accommodated, if not in the vehicle where the ballot box is being transported, but maybe another vehicle accompanying them to ensure that it is safely delivered to the RO office or the supernumerary RO office in some regions. And what is wrong with that? It is not about the PVP agent alone. It is about all the polling agents representing all the different political parties. So these amendments, Mr. Speaker, is about bringing forward a fairness to the process. Is ensuring that we have an electoral process that is root-proof, because we have seen in 2020, even though we have a strong electoral system, an electoral system of verification, of identifying voters, of voting, counting, we have seen where people use their discretion or abuse their discretion to favor political parties. And that is what we are seeking to change in these amendments by taking those out. Mr. Speaker, I want to wrap up because I know maybe my time is going. I want to wrap up on the issue of consultation. There have been so many consultations held on ROPA. ROPA has been in the public domain for almost a year or maybe over a year, Mr. Speaker, where every single Guyanese, every single organization in and out of Guyana had an opportunity to make their presentation, to make their submissions, to make their contributions. And I have personally seen many submissions from a lot of organizations in Guyana. I've personally seen that, but none from the opposition. None from the opposition that's being paid with taxpayers' money, that enjoy the same benefits as our MPs over here, because there is no interest. But yet they come to the National Assembly and say, Senator Special Select Committee, without a single recommendation, without speaking on a single issue, without saying that, you know what, we support splitting Region 4 into 4 subdivisions, because it would help with the transparency and the efficiency of the process of tabulation, counting votes and tabulation. We have not heard that. We have not heard them come in and say, you know what, it is a good thing that we are reducing the number of voters per polling station to 400, because we believe that 400 persons can adequately vote at the polling station without any interruption. And 500 is too much, or 600 is too much. We have not heard, oh, it's good that polling stations are within the districts or close proximity to the people who are voting. We have not heard a single comment on the amendments that are being made in the Representation of People Act this evening, Mr. Speaker. But yet all we heard is about Senator Select Committee. We heard about how the context is charandas, the context is blackout, the context is bad infrastructure. I don't know, Mr. Speaker, how the context of the amendments here can be about those things. So, Mr. Speaker, it shows that we have an opposition that obviously don't value democracy. They don't value the rights of our people, and they're not willing, or they're maybe not able to represent their constituency. And yes, the honorable member is right. They have a large constituency. The last elections, 216,000 Guyanese voted for the opposition. The figures are there, it's public. And we respect that. As a matter of fact, we love the 216 voters. We're trying to win them over right now, with much success too. So we are representing them. We are representing all of Guyana. We're not only representing the people who voted for the People's Progressive Party. And these changes here are being made to safeguard the rights of every single Guyanese. Every single Guyanese, regardless of which political party you support. Because every single Guyanese would like to know that their vote is secured, that is counted, and their rights are protected when it's being tabulated or declared at the end of the election. So these amendments, Mr. Speaker, is a representation of the will of the people. It is a representation of good governance. It is a representation of true democracy. And as a government, creating a new modern Guyana, we will continue to make amendments to strengthen every single process, including our electoral laws. So, Mr. Speaker, I wish to fully support the representation of People Amendment Bill 2022 and for successful passage in this House this evening. Thank you.
Thank you very much, Honorable Minister of Natural Resources. Now call on the Honorable Royce Ford SC to make this contribution.
Thank you, Mr. Speaker. Mr. Speaker, having listened to the Honorable Minister Bharat and listened to the Attorney General speak before, one might feel that the motivations for this bill or that the reality or the purpose for which this bill was brought to this House would have been actuated by the best of motives. Regrettably, Mr. Speaker, we all too well know that the political context that brought this bill is one in which the People's Progressive Party seeks to put in place a mechanism and a regime that is self-serving. Mr. Speaker, it came out very clearly in the repeated comments made by Honorable Member Bharat. For most of his presentation, he made bare to the public and to the citizens of this country that this bill was motivated by what they were told, we were told, being the People's Progressive Party, and the measures that they wanted to put in place in terms of their subjective understanding, of their subjective reality as to what is necessary to change the system. Mr. Speaker, as in any system, those who would have emerged victorious, whether by plunder, whether by fraud, whether by deceit, but takes governmental control, will obviously seek to implement a system that supports them. But Mr. Speaker, it cannot be denied that a number of areas of importance for the people of this country that the People's Progressive Party this evening wants to speak so much about are not captured in this bill. And why, Mr. Speaker, it's not captured in the bill? Because obviously, listening to what Honorable Minister Bharat said, it would not have been the things that they would have been heard or would have been told to them. For example, Mr. Speaker, the recount period revealed numerous and hundreds of instances of voter impersonation. It revealed, Mr. Speaker, hundreds of thousands of instances of multiple voting. It reveals hundreds or thousands of instances of substitute voting, and certainly indicated and revealed, Honorable Speaker, instances of persons who were deceased and recorded as having been voted. And also, Mr. Speaker, they reveal instances of persons who would not have been in the country at the time and would be recorded as voting. Mr. Speaker, the absence or the failure by the People's Progressive Party to address these issues leads one to come to the conclusion that they are comfortable with such a state of affairs, that they wish to benefit and continue to benefit politically from such a state of affairs. Mr. Speaker, isn't it amazing that the Honorable Mr. Bharat will come to this House and in the course of his odd 20 minutes presentation, say at least twice that his party supports biometrics, but it must be used in complement used in complement to the existing system. We would have thought, Mr. Speaker, that such an important and remarkable discovery made by Minister Barra this evening would have formed an essential part of this bill. But, Mr. Speaker, it is easy to talk the talk. It is easy to talk the talk about biometrics, but to come up short in this bill on the issue of implementing such a system because it is absent from the bill altogether. Mr. Speaker, the first speaker on our side clearly pointed out the circumstances and the obvious rhetoric which was absent. Because if you want to come and you want to speak about electoral reform and you want to start not many years ago, you don't want to speak about a chief elections officer who almost ran off with an election years ago. You don't want to speak about a chairman of an election commission who publicly told the president or the incoming president that was good and later became an attorney general of the People's Progressive Party, Civic. And you don't want to speak about a prime minister who sat on a seat that he's not entitled to. You don't want to speak about the chief elections officer coming up with a different electoral system to calculate ballots. You certainly want to keep the issues purely in a context of a political divide. And you're not coming to the table with your hands clean. Mr. Speaker, the greatest irony tonight, Mr. Speaker, the greatest irony tonight is that such a bill of such importance would have been brought to this House by the Honorable Attorney General, who himself, in the course of these electoral matters, himself mention was made of his participation one way or another in relation to ID cards. Mr. Speaker, that is probably among some of the greatest ironies that affect the preliminary matters in relation to this bill. But, Mr. Speaker, I would like to address three areas of concern in relation to the bill. First, Mr. Speaker, the bill proceeds based on what the Honorable Attorney General said to deal with the issue of residency. And I understand and appreciate his efforts to remove residency. I understand it from a legal perspective, and I understand it more so from a political perspective. And certainly the question of residency will not operate to the benefit of the People's Progressive Party. But what I'm concerned about, Mr. Speaker, for example, and I will refer to the bills alternately, when we look at, for example, Clause 4 of the National Registration Amendment Bill, it seeks to replace, and even in the representation of the amendment bill, seek to replace the reference to residence with an application, with an address or the date of the application. But certainly, Mr. Speaker, at 4D, the reference is made to the fact that on a successful verification of the address, the particulars of the first-time registrant has to be determined by the officials of the Guyana Elections Commission. Mr. Speaker, qualitatively, the issue of residency had historically formed part of our criteria for an assessment of the allocation or location of a member of the public as to where they would have voted. That would have been said by the Chief Justice in the Christopher Ram matter. That even though in her opinion, which we disagree with, but respectfully, even though she said that there's no issue of a residency requirement, residency was important in terms of allocating a person as to where they should vote. And she went on in her decision, it's right here, being objective, it's right here, to say that in those instances, it is where the person lives. Now, Mr. Speaker, what we have here is the fact that the learned Chief Justice, in her decision, made that position clear. And even though up to now it has not been vocalized by the Attorney General, clearly in his mind or in the mind of his government, was the fact as to how could I deal with that issue in view of the statement of the Chief Justice. But to remove residency requirement, Mr. Speaker, altogether for resident Guyanese and to put in place the phrase with a registered address across the board, Mr. Speaker, for all Guyanese persons who are seeking to be registered, whether they're resident or not. In my respectful opinion and in my party's position this evening, Mr. Speaker, is that it brings into question or brings into the legislation a very important area now that is unclear, because now they must produce proof of address. There's no recognition in terms of what is the assessment that the Guyana Elections Commission is to engage in the verification of the address. So, Mr. Speaker, we believe that that is an area that ought to be fixed and addressed in the bill. Mr. Speaker, the issue of the new systems of Region 3, 4, and 6 and its subdivision, whilst it may be motivated, according to the other side, by their understanding of what is in the best interest of the Guyanese people, Mr. Speaker, these represent only 3 of 10 administrative regions. And automatically, Mr. Speaker, this will be the first time that our electoral system will have differences in the manner in which votes are counted and tabulated throughout the system. We believe, Mr. Speaker, and I'm happy to hear the Attorney General says that he agrees that that is the intent. Mr. Speaker, we believe that this opens the system clearly on the face of the legislation for the creation of an inequitable system that is partially structured in a particular way in relation to those regions. While the same concerns that existed or probably would have motivated this effort remains extant for the other remaining regions. Mr. Speaker, the Attorney General and I would like to commend the staff of the Attorney General Chambers for the obviously tremendous work that they would have undertaken in the attempt to rationalize and to put in place different aspects of this act into the respective areas. But I believe, Mr. Speaker, there's one significant area of the attempt which requires some review, and that is Section 33A6. 33A6 of the Representation of the People's Act. Mr. Speaker, without the obvious change in 33A6, which previously I believe was Section 5.6 of the Election Laws Amendment Act, which has now been changed to deal with the question of a registered address instead of residency. Mr. Speaker, this provision came into existence in Section 5.6 originally of the Election Laws Amendment Act. And it's important to note, Mr. Speaker, that at no time in relation to local government elections was this provision applied in relation to local government elections to the extraction of a list. In 2016 and 2018, the local government election laws was used, and in relation to the 1994 elections, the PPP government passed a specific amendment to deal with the use of the 1992, I believe, electoral list. So, Mr. Speaker, this is the first time that this provision is being used in a local government election. And what it does, Mr. Speaker, whilst maintaining in the Local Government Amendment Act, or the Local Government Elections Act, specific provisions dealing with the manner of preparation of a register of voters, deals with the manner in which a register of voters is to be produced, and more importantly, Mr. Speaker, the Local Authority Elections Act deals specifically with the standards or the qualifying criteria for electing those elections. In this one, in 33A6, it specifically says that the Commission, if it so directs, notwithstanding anything set out in any other law, allows you to use the electoral laws dealing with the election of the National Assembly. So, Mr. Speaker, what Section 33A6 in its present format does is to give the Elections Commission, and I respectfully believe, Mr. Speaker, and my party feels so too, that it gives the Commission the option of determining what would be the criteria. Because, Mr. Speaker, under 33A6, the persons who are to vote would be the persons with a registered address in a local democratic organ. But if you look at Section 10 and 8 of the Local Authorities Election Act, you would see, Mr. Speaker, it is a person who's ordinarily resident. So even though in the current cycle of local government elections, the list would have already been extracted without reference to persons with a registered address, it would have been extracted on the basis of persons who would have simply been resident in the local authority area. And the definition, Mr. Speaker, of resident under this act and ordinarily resident under the Local Authority Elections Act are two completely different provisions. Mr. Speaker, when you actually look at the introductory language in the Election Laws Amendment Act, it says that it was to pass laws in relation to the National Assembly. This section falls into now completely into the Representations of the People's Act, which says specifically that it's to pass laws for the elections to the National Assembly. But we have this anomalous section, I believe, lying here in Section 33E6. Mr. Speaker, we believe that this bill cannot be supported by the opposition, and we do not offer our support to this bill. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Member, Mr. Ford. And now for the Honorable Member and Minister of Public Service, Ms. Sonia Pearl.
Mr. Speaker, I stand in full support of my colleague, the Attorney General, in bringing Bill number 24 of 2022 to this honorable House. And I will begin by saying that I have sat here most of the evening, as my colleagues have as well, and we've listened. And I've heard the Honorable Member Amanza Walton Desir state a lot about nothing relevant to this bill. I've also heard the Honorable Roysdale Ford, who didn't say as much, but still about nothing. Mr. Speaker, the Honorable Member says every time that they come to this House, they will come and they will tell you about a bloated list and they will tell you about the 2020 elections. Mr. Speaker, every single time we come to this House, we have to remind this country over and over the trauma that they put the Guyanese people through, and we will not stop. We will not stop. Every single time there is a piece of legislation that is passed by the Honorable Attorney General and this side of the House, it is because of democracy. It is because we want democracy to prevail. The members on that side of the House, Mr. Speaker, they are anti-democratic. They are anti-progressive. They are anti-development. And they are anti-Guyanese. March 2nd, 2020 to August 2nd, 2020 was undoubtedly one of the darkest, most heart-rending periods of our nation's history. Anyone who knows the history of Guyana will associate rigging of elections with the PNC, and I will borrow a phrase that my honorable friend on the other side used tonight, associated with the PNC, now a sham of a reform to APNU AFC. It didn't change what their true nature is, Mr. Speaker, to always be undemocratic. Every single time I come here, and I don't know if it's the same thing for my colleagues, but every single time I come here to this honorable House and we present a bill, it shocks me that words like democracy and the Constitution and upholding the law comes out of their mouth. Mr. Speaker, a lot of us, and I can tell you I worked on elections day. I worked at the recount all 33 days. I worked at Ashman's building. And Mr. Speaker, just before the elections, I was doing my work, and the Honorable Attorney General, who is the election agent for the East Coast, placed me the night before in a different area. And I can tell you that the process and the system that is in place for elections is a robust system. So what the ROPA is, the amendments in the ROPA today that we are trying to pass and seeking to pass, Mr. Speaker, is to strengthen the integrity, the integrity that already exists, but to strengthen the integrity of the electoral system. Electoral reform is something that we promised this nation. It is something that was necessary and relevant and became a priority after the 2020 elections. Never in the history of our country were we able to see exactly what the PNC and their operatives and their minions would have done. This is the bill. This is the bill. Mr. Speaker, when I went to a polling station to vote in my area, I voted without an ID card. I voted with an ID. I had to go through all of the processes set out by the law, by the manual. I was identified and the process was followed. There was an agent for the APNU AFC. There was an agent for the PPP. Likewise, when I went to the district in which I worked and sat in as a polling agent when my polling agents went to vote, I had the first-hand experience of working the system, and it worked. It was strong. It still is. The problem that we had, Mr. Speaker, is the rogue elements in the GCOM. Nobody wants to address that. They want to deflect with a bloated list and biometrics, and this is what we need to do. The real problem was the rogue individuals, the Claremont Mingos. And I dare say, Mr. Speaker.
But, Honorable Member, we're going to have to refrain from naming people who can't represent themselves. And while I'm at it, be careful how you talk about those on the opposition, because the Honorable Deputy Speaker is waving his hands at me. Please.
Except, of course, the Honorable Deputy Speaker. But I dare say as well, Mr. Speaker, I dare say, Mr. Speaker, that we have an honorable member in this House that sits on the other side, that walked, not stood up and went up an escalator, walked up an escalator to go sign fraudulently a declaration when the Conquer Region 4 wasn't even completed. It is because of those fraudulent actions that a bill is brought here today, Mr. Speaker, and it is for the world to see, and it is the Honorable Walter Lawrence. I will call the name. Mr. Speaker, this country must never forget that it was held by a very thin thread, that it could have come crashing down. For 5 months, people couldn't sleep. People could not sleep. They could not eat. They could not move on with their lives. All because you had elements who wanted to steal an elections and hold an entire country hostage. But, Mr. Speaker, the difference in 2020 is that they weren't as smart as their leaders before. They put it on national television and didn't care. They put it on social media and didn't care. They put it for the entire world and didn't care. But Guyanese cared. They cared enough, all the right thinking Guyanese cared, whether they were here or they were abroad. They cared enough to fight for their country and to fight for democracy. And Mr. Speaker, we on this side of the House, and I believe I can speak for all of my colleagues on this side of the House, we will never, ever allow the opposition or any rogue elements to hold this country hostage ever again. Ever again. Mr. Speaker, I would like to speak as to the consultation of this particular bill. Now, the honorable member, Ms. Amanza Desir, said that she's suggesting that the bill goes to the select committee. Mr. Speaker, I will humbly beg to differ because this bill, this is the second reading. We are debating this bill. This bill has been laid in this parliament many moons ago. There was enough time for that to be raised. Not only that, Mr. Speaker, this bill was, all the amendments in this bill was placed on the websites of Ministry of Parliamentary Affairs and Governance. And you know what's worse, Mr. Speaker? Is that I sit in a committee on the IRI just as the honorable member, and I have brought it to their attention many times that it is on that website. Not only that, Mr. Speaker, but I actually attended the in-person consultation that was held by the Attorney General, the Honorable Attorney General, and the Honorable Minister of Parliamentary Affairs and Governance with different stakeholders of this country. And a lot of people attended. I was here in person. And you know what else, Mr. Speaker? The Honorable Mr. Ramchatan was here representing the opposition. The Honorable Member Tabitha Sarabo Hali, suspended, was also attended that consultation. And Mr. Speaker, their response to the Attorney General's presentation was to suck their teeth, get up and suck their teeth. And we all know what Guyanese, when Guyanese suck their teeth, what it means. Get up and suck their teeth and walked out of this honorable house. Walked out of this honorable house without contributing anything, without saying anything meaningful. As a matter of fact, they said nothing. They just walked out. While other stakeholders came and made their contributions, in addition to contributions that were made online. So for the honorable member to come here and pretend as if this bill is now coming and what is it, rammed down their throats, I don't think so. I do not think so. Because I have been through the process from beginning as well. And many others who do not belong to the PPPC or the APNU AFC came along on this journey as well and made their contributions. So, Mr. Speaker, this bill will be passed tonight because it is long overdue. Mr. Speaker, I would like to bring up the issue of the bloated list. We've been told so much about how this list is bloated and they're opposing this list going ahead, even taking it to court because they claim it's bloated. Mind you, in 2015, the same list was there and they won and they accepted their winnings on this list. How hypocritical can you be? On top of that, Mr. Speaker, in addition to that, for you to remove anyone from a list, it would be unconstitutional. But then again, I don't expect the members on the opposite side, except for Mr. Schuman, to come and say anything differently because they have never been constitutionally inclined. But they have come, they've asked for a list to be cleansed. Our Elections Act of 2001 provides for continuous registration. We are even adding to that by having continuous registration throughout the year. That takes care of anything on the list that you have registered, dead voters, etc., etc. And the Honorable Chief Justice would have ruled. She ruled on the matter, And she said, you can't take people off the list because guess why, Mr. Speaker? The Constitution states at Article 159, every person may vote at an election if he is of the age of 18 years and upwards and is either a citizen of Guyana or a Commonwealth citizen domiciled and resident in Guyana. You cannot wipe away somebody from a list who is a citizen of Guyana because you believe the list is bloated. So it is unconstitutional. If you want that, then you go and table something for the Constitution to be reformed. As it relates to biometrics, first of all, we have biometrics in this country that was implemented in 2008, and it was done so with a heavy financial, yes, it carried a heavy financial burden. But you know what? It was implemented. What you don't want to tell the people, Mr. Speaker, and I don't mean you, what the honorable members on the other side doesn't want to tell the Guyanese people is that they want to be able to disenfranchise voters. We, the government, the PPPC administration, will not make decisions that will disenfranchise anyone. As a matter of fact, we will make it more inclusive, which is what the ROPA is doing right now. I do not listen to irrelevance. Mr. Speaker, the system that we have in place, the mechanisms that we have in place on elections day makes it virtually impossible for you to have impersonation. So when you want to gain political mileage, you have to make sense. They're not making sense. Mr. Speaker, as it relates again to the biometrics. There is no requirement in our Constitution for biometrics. And you know, this was tested in the Esther Pereira case of 1998, albeit that addressed an issue with an ID card. And the Honorable Justice Claudette Singh, who presided over that case, concluded that the right to vote is recognized as a constitutionally protected right and can only and imagine you want to go the other way. Imagine you sit there and want to go the other way. Constitutionally and can only use that right in accordance with the Constitution and no other method. So, Mr. Speaker, when they want to bring biometrics, they're not telling the country that when people go to vote at a polling station and they want to use electronic voting, etc., because basically that's what they're calling biometrics, people will have to only vote by electronic voting or by biometrics. So if somebody can't vote like that, they're left off the list. They're disenfranchised. And that is what they don't want to tell people. That is why it is unconstitutional. And as a matter of fact, that system isn't broken in our country where we have biometrics. So why are we fixing something, or why must we fix something that is not broken? No. You shut your mouth when you were in there. No, I'm not saying to shut your mouth here. I said she shut her mouth there when I said it.
But you know, I think some MP today used another ingenious word.
She
Hush.
closed her mouth quietly when she was in there, sir. Now, Mr. Speaker, of all the amendments being proposed here today, I believe that we can agree that one of the most significant is the proposal to implement hefty fines of up to $10 million and lengthy imprisonment of 10 years on persons found guilty of electoral misconduct or fraud. Now, Mr. Speaker, speaking directly to the amendments now, I've also heard the honorable members on the other side say it's archaic and it's draconian. Mr. Speaker, this is actually progressive. You can never allow a rogue element in an administration, such as GCOM, to hold an entire or to violate people in the most heinous way you can do. And they get away with nothing. So when they say that this is going to act as a deterrent for people who are qualified, I have to ask the question, those people are coming with the intention of rigging an elections? Because if you're coming with clean intentions and you're going to do your work, this shouldn't affect you. So, Mr. Speaker, these penalties, yes, they are to act as a deterrent. And it is exactly because we experienced what we experienced in 2020. And I am sitting there 33 days, Mr. Speaker, and members of the opposition, as well as the CEO and the DCEO of GCOM at that time. Circumvent would be too small a word. You know, probably we should bring it to the public's attention that the shadow minister of legal affairs and the shadow attorney general is mimicking the situation that happened in 2020. Sitting on the opposite side right now, mimicking the situation that happened in 2020. That is also mimicking the situation.
Honorable Minister, let me just again caution the Honorable Member, Mr. Ford, about interrupting people. There's a standing order with that. We won't condone that behavior in the House. Go ahead, Honorable Minister.
Yes. Mr. Speaker, this bill introduces Section 78B, which specifies it as an offense to mislead an elector or provide them with misleading directions or information. We are also trying to make voting easier for persons without identification cards who, under the amendment, could be accommodated using an alternative form of identification in the form of their Guyana passport. Mr. Speaker, as you know, we are proposing several amendments to Section 84 of the ROPA, one of which includes increasing the number of persons who can inform a presiding officer of a material error on the SOPs to not only a counting agent and a polling agent, but also a duly appointed candidate as well. This particular section also sets out to have requests for a recount of the votes be submitted in writing by hand to the returning officer or to the deputy returning officer of a particular district. In a case where those two officers are unavailable, the request would be directed to whomever was appointed as the standing returning officer or the supernumerary, as we would say in legal language. Should all of these persons be unavailable for whatever reason, the request for recount can either go straight to the Chief Elections Officer or directly to the chairperson of the Elections Commission. We have also included a new subsection which would require that certified copies of each tabulation form sent to the CEO must also be given to the appointed candidates and the counting agents and the chairperson of the commission. Again, these tabulation forms must also be posted online on the commission's website. Social media played an important role in exposing the discrepancies of the 2020 elections. So it's quite fitting for us to now use it as a tool to prevent any further attempt at skullduggery. It is, in a sense, ensuring that we cross our T's and dot our I's. Mr. Speaker, if the government has to continuously school and spoon feed the grossly inactive members of the APNU AFC on every matter brought before this House, we would have no time left to run this country. So I will end my presentation here and by saying that this amendment bill was crafted with a long consultative process which benefited from the impactful contributions of the majority of key stakeholders. It is a bill which seeks to save us from the heartache and trauma that characterized 2020 for us. Mr. Speaker, I commend this bill to this House, and I fully again support the ROPA. It is something that is going to enhance our integrity of our electoral system, and I cannot emphasize that enough. We have recognized, we have promised, and we are delivering. Mr. Speaker, I thank you.
Thank you very much, Honorable Minister of the Public Service, Honorable Sonia Parag. Now call on the Honorable Member, Mr. Sanjeev Tatadin, to make his presentation.
Good evening, Mr. Speaker. Mr. Speaker, in every society, the laws must evolve to meet the needs of the citizens. This amendment, the Representation of the People Amendment Bill, Bill number 24 of 2022, is such a piece of legislation. May I add that I fully support this bill and commend the Honorable Attorney General at an exceptional effort to organize our electoral laws, which, as he alluded to, was located in diverse amendments and pieces of legislation. And for those of us who, from the time the government fell in 2018 until the swearing in of President Irfan Ali in August of 2022, had no easy task, constantly keeping track of the legislation, where it was located and which one was applicable. Mr. Speaker, the insane and blatant attempts to steal an election in 2020 must never happen again. In 2020, Splashman's building was a circus. Mr. Speaker, there were many unorthodox performers. The clear language of the legislation was simply cast aside. Bizarre and utterly ridiculous interpretations were afforded to the law. Simple things, Mr. Speaker, became so complicated that you began to wonder what had become of English language. Despite clear language, the returning officer refused to use the SOPs in tabulating the results for District 4. Despite an order from a High Court judge, that same returning officer refused to use the SOPs. It is interesting to note that that returning officer insisted on using a spreadsheet. No one knows where it was prepared and where the numbers on that spreadsheet come from. But surprisingly, a member of this House sitting who was at that recount, the Honorable Ms. Valda Lawrence, said that those numbers matched her SOPs. And to this day, Mr. Speaker, we have not seen those SOPs. Mr. Speaker, the law cannot allow that. These amendments are necessary. The SOPs must be used and displayed. That is the amendment to Section 84 of the Act. In clear, crystal language, it must be displayed by electronic means. And if it is not done so, and you willfully don't do it, then you are subject to imprisonment and a fine. Mr. Speaker, permit me the latitude. Perhaps there should be more severe penalties, and they are more, but it doesn't warrant, perhaps, on this occasion. But for what was happening then, Mr. Speaker, when a nation, an entire nation, was on its knees, powerless to stop a public official from taking a perverse and bizarre route to interpreting statute, which was written in plain English. He simply did not want to use the SOPs. The laws have been amended to address that too. When he receives the SOPs in the amendment, Mr. Speaker, he is now obliged to display it on the web, on a website. So he can't sit on it forever. The CEO, the Chief Elections Officer of GCOM, is obliged to do the same. We all remember that the last Chief Elections Officer, despite receiving SOPs, refused to use them in any way, fashion, or form, or to disclose them to anyone, so that the circus with its multiple performers would have come to an end. Instead, they were concealed. They are concealed to this day. Instead, the law was interpreted, and the interpretations, the perverse interpretations, pervade to this day. Mr. Speaker, to refuse to use the SOPs by that returning officer, despite a clear order from the Chief Justice, where the Chief Justice sent to call him, to make him be present in court, and explain to him that he had to use the SOPs under Section 84 of the then Act, and he refused. He graduated to GCOM's building. He used bed sheets, white bed sheets, and a projector with the setting sun behind you, with a white bed sheet and a projector. My friend and colleague, the Honorable Minister Sonia Parag, had the unenviable task of sitting in that room, unsupported, to have and to try to decipher a very fast flow of numbers. Slides in that environment, in those circumstances, Mr. Speaker, must be seen for what it was, an attempt to steal an election. Now, Mr. Speaker, what happens then? What happens under the amendment of the law, Your Honor? The new Section 83B of the Act requires posting online electronic copies of the statement of poll. The returning officer is obliged to do this. Now, in the count, every person, every party, every candidate is allowed to be present when that count is taking place. That tabulation is taking place from the SOPs. Now, if it is, as was the case, it was pointed out to the returning officer that these numbers you're calling is like a game of bingo. No one else has them, and we're not sure if we've covered all. But the position was ignored. The returning officer kept going. The party scrutineers, the candidates, the polling agents were powerless to stop him. So this is why the law has to be amended, because one man has proven that simple English language is insufficient, and he feared nothing at that point. So, Mr. Speaker, now, under the law, if there is an objection, the returning officer cannot move on until he's resolved it and addressed whatever the concern is. He must use the SOPs, the originals that he used. He must display those using electronic means so that everyone can follow, which was being done, in fact, in the same Ashman's building for 2 days. It then suddenly stopped. Now, where there is a material error, Mr. Speaker, in a statement of poll, an election officer or a counting agent can ask for it to be corrected. The displays must suit and conform with what the other persons who were there agree to. The presiding officer shall post the original. If there are corrections, he shall post the original and the corrected ones at the place of poll. The display that is required by law now, Mr. Speaker, must be accompanied by catering and listening to whatever complaints they are about the numbers. So in the past, where we had bed sheets and we had situations where in that building at GCOM on High Street, Mr. Speaker, one person was allowed in. The Honorable Minister Parag was the person that was there. Nobody else was allowed in that claimed or represented the PPP. Candidates were not allowed into that count, despite the law clearly saying candidates could be present. The counting agents were not allowed, despite the clear wording of Section 84. Mr. Yearwood, I think it was. That's when Mr. Yearwood was charged. Now, Mr. Speaker, in a most astonishing situation, at Ashman's building, despite an order from the court, the returning officer, who was hospitalized initially, miraculously returned on the following day, did not start to do his work at 9 a.m. as was promised, but came downstairs with a sheet of paper in the room where the tabulation was taking place, supported and egged on by a member of this House to read his results. He was not permitted to do that because of the vociferous objections of all who were present. The Honorable Minister of Agriculture was present, the Minister of Human Services and Social Security. There were so many that were present. The Minister of Natural Resources, Mr. Vikram Bharat, I'd never heard him scream so loudly then or since. But, Mr. Speaker, he was not allowed, the returning officer, Mr. Bingo, could not read those results because they had not been tabulated in the presence of anyone, whether from a spreadsheet, a bed sheet, or the SOPs. They had not been done. But he said he could do it, despite the clear law that it had to be done in the presence of the party polling agents. So he went to do it. He was not able to do it. He turned, he walked away, he went upstairs, and 2 hours later, 2 floors up, in a very cowardly manner, hiding from everyone, he proceeded, or he purported to declare the results. Mr. Speaker, that was such a transparent attempt to not count and not tabulate the votes. Then, having made that declaration, and the court had ordered that there be the tabulation be made from the SOPs, Mr. Speaker, that's when we went to GCOM's building. And lo and behold, he declared another set of numbers. And lo and behold, the member in this house had those numbers too, to confirm them. But, Mr. Speaker, importantly, no one seemed to recognize that this returning officer was a magician. He got no credit for the magic he performed. He changed numbers magically within days. And he was able to have a member of this house have those magical numbers too. It's like a card trick, Mr. Speaker. You take a pack, you tell the guy, hold a card, and then you find his card. This is what happened. He took the honorable member's numbers and he found it later. Mr. Speaker, now, we will not be a country to lock candidates out of the count. To get a recount, Mr. Speaker, curiously by law, it had to be by 12 p.m. the next day from the declaration. But it had to be by a polling agent. Now, a counting agent. Mr. Speaker, the counting agent and the approval of the counting agent was part of the responsibility of the chief elections officer. We managed to go into the 2020 elections, Mr. Speaker, without a single appointed, approved counting agent to any political party. The CEO, whose responsibility it was, must take the blame for that. But all the candidates stood up powerless to stop that process. In the end, Mr. Speaker, we now have a law that says the counting agents or the candidates can make the request for a recount and it shall be granted. Also, we couldn't find the returning officer. He had disappeared again. Now, under an interpretation of the law, it is that you will have to go to any returning officer. Now, the CEO had disappeared. The deputy CEO who was there wouldn't let people into the premises. And, Mr. Speaker, the chairman, the whereabouts were unknown. The Ashman's building, which had been a hive of activity with all the persons, including those who had to be lectured to by the honorable member, Ms. Karen Cummings, about what they were allowed to do as observers, that will no longer happen, Mr. Speaker. Because now we don't need to find any, we have so many options. We can find the returning officer, a deputy returning officer, the CEO, the deputy CEO, the chairman. We have now, by power of law, requesting a recount should not be that difficult. It should not be the 10 tasks of Hercules. It should be a democratic right. We now have a law that says that that is the democratic right. Now, Mr. Speaker, we now have the issue of the declaration. We're going through this process. So we do the tabulation, we have to declare. Now, the returning officer must declare. Now, he wants to declare whenever he wants. He wants to declare in his own private time, That's no longer allowed. Now, we still don't know why the Honorable Member, Ms. Valda Lawrence, signed Mr. Mingo's declaration. It's quite a curious thing. And I would dare like to know how it was that a then minister, a candidate, a chairman of one of the political parties, was able to access Mr. Mingo in time to sign as a witness to what he was doing. Now, this was the curious thing. Why do you want to witness that? And Mr. Speaker, how could one side of the political divide, a person who was a sitting minister of government, sign as a witness? Mr. Speaker, now it's easy. There's a time limit within which it has to be done, and it has to be posted online, so the whole world could see it. And if you're a clown enough to want to sign it for your own reason, by all means, sign. But, Mr. Speaker, there was an even curious thing that followed. Following that signature, on the second declaration a week ago, there was another signature, a Carol Joseph, who was a candidate, who was a petroleum director, I'm told, but who was also a member of a political party. How did they get to sign Mr. Mingo's declarations? Mr. Speaker, that thankfully has been consigned. Now, Mr. Speaker, thankfully, this statute makes it clear that when you make the request for a recount, it must be granted, so it will be undertaken. The Honorable Attorney General has gone to great pains to indicate that in the areas where there is the population density, region 4, 6, and 3, it's now been separated. So the separation should allow for better transparency, Mr. Speaker, because there is not now one Mingo, they have to be 4. 3 more. So that's what has to happen. Now it makes it harder because of the spreading, but it also makes it much harder, Mr. Speaker, because of the requirement now that the website that exists, that these things be published. Now, Mr. Speaker, you will recall that the PPP, the Vice President announced that all of the PPP's SOPs were made public. They were put on a website and published online for the whole world to see. We have still not seen the SOPs of the APNU AFC despite repeated promises. We haven't seen it yet. Now, Mr. Speaker, again, Mr. Speaker, legislation is born to meet the needs of the citizens. Now, we must remember, Mr. Speaker, that if you were at the Ashman's building when the returning officer fell ill and went to hospital, and he later came back miraculously, he was supported by members of this House who were there. And that inference of interference will never, ever go away. The whole world saw it. The whole country saw it, Mr. Speaker. Now, then we had an even more curious position where Mr. Lowenfield, who was the CEO, he then had to tabulate 10 pieces of paper. What was written on 10 pieces of paper, he had to tabulate and come up with 1 piece of paper. My 4-year-old son can do that quite efficiently. But it took him nearly 2 weeks, and he did it wrong. How could that be? The CEO ascribed a meaning to votes in the law to mean valid votes. Mr. Speaker, I'm not sure what in heaven's name else were we counting other than valid votes. But a member of this House, in being the representative of the CEO, went to the court and said this could only be valid votes, and therefore Mr. Mingo, another magician, is able to decide valid votes. Mr. Speaker, Mr. Mingo, like Mr. Lowenfield, like Mr. Mingo, came back with an even different set of numbers. Again, a magician, which we did not give credit to. So the first set of numbers he produced, he did not explain how he came to it. The second set, he did not. He went to court to say that it meant valid votes, and then had the audacity to tell the nation that having received a ruling from the Court of Appeal of Guyana, which at best could be described as bizarre, he then had the audacity to tell the nation that you can't go and appeal this. And you can't go to the Caribbean Court of Justice, our apex court, because this court's ruling is final. Mr. Speaker, a battery of lawyers from as far as Antigua, St. Kitts, Trinidad, Grenada, Belize, across the Caribbean, stood in support of that nonsense to tell this country that you have to stand with whatever it is the CEO and the bizarre ruling of the Guyana Court of Appeal was. Thankfully, Mr. Speaker, despite all of the legal luminaries across the Caribbean Court of Justice was simple. Valid votes could only mean valid votes, and essentially said to Mr. Lowenfield, just go back and add the numbers. You have no discretion. You cannot decide for yourself. Mr. Speaker, if, and I'm sure you may have been aware, during that time where the CEO was deciding how he would display his numbers and which ones he would pick and what issues he would do, those of us who were trying to figure out the legal ways of going around it could not imagine what would happen. Mr. Mingo at one time wanted to convene a meeting with everybody and hold a hearing to decide which were votes were valid and which were not. Mr. Speaker, this was beyond preposterous. It was like, for 5 months, Mr. Speaker, it's like watching a bad movie that wouldn't end. Scary would be an understatement. It was impossible. However, so now we have a law. The amendment to the law is he has a fixed period of time, 12 hours, within which he must do the tabulation. When he does the tabulation, he must publish it to a website. He must give it to the chairman of GCOM. He must give it to the scrutineers. So, Mr. Speaker, all of that held a country hostage for 2 months is no more. It is very clear. If he does not do it, Mr. Speaker, then comes the jail and the fines. And it is very clear and expressed what will constitute the jail and the fines. Now, a symptom of what was experienced in the courts, we witnessed in this House shortly, a little while ago. The honorable member said hundreds of thousands of multiple voting, hundreds of thousands of dead people voting, hundreds of thousands of instances of electoral fraud. Mr. Speaker, as I understand it, we only totaled about 400. There were only about 400,000 votes in total. So we passed the 100% of that now. This is what the honorable member, Mr. Ford, said. Hundreds of thousands. So the thing is, Mr. Speaker, this is why the law was necessary. Because simple English language and the truth are divorced from the honorable member. The indication is a bold promotion, Mr. Speaker, of a false narrative, supported by the typical twisted and bizarre interpretations and a narrative that we witnessed in the electoral cases. It is akin to the nonsensical theory that was espoused for months and in fact supported by the Court of Appeal that 33 was not the majority of 65. Once again, my 4-year-old Sawyer knows that that is different. But, Mr. Speaker, it is important as a record in this House, we do not let it be said that these sorts of figures have any bearing to reality. Those assertions, Mr. Speaker, are unsupported by any fact whatsoever. Those assertions are untenable and could not stand. Now, there is and there was the issue of biometrics and the use of biometrics. Mr. Speaker, I only wish to add one short thing to that. Biometrics are already in use. They are used for the benefit of GCOM. There is no need for it to go any further. It will unduly complicate a very effective system of voting, which, not being electronic, is very difficult to manipulate. Its simplicity, being primitive, is its strength. Mr. Speaker, this strong law that we had before is now being made stronger. This simple language is being made more explicit. Mr. Speaker, I support this bill. It protects every citizen of this country from tyranny. Thank you, Mr. Speaker.
Thank you very much, Honorable Member, Mr. Datadin. And now for the Honorable Member, Mr. Kemraj Ramjatan.
Speaker, and I want to indicate that for a very long time, whilst this bill was present in this Parliament, I had indicated that we have a law revision commission set up with a Justice of Appeal Roy heading it, which ought to be the body which should have reviewed and dealt with these amendments. Because it is an expert area. You feel that there isn't a bias in you that is going to be entrenched in these amendments as a result of your having participated in the election. And we have been creating institutions of this government 49% of the opposition and you can give yourself the 51%, it is necessary then that the Attorney General's chambers must make sure that it insulates its prejudices by virtue of letting it go into the Law Revision Commission that you created. But you did not do that. You did not do that. And let me say that in consultations too, it is not an area that those who you would be dealing with in very high constitutional matters will be the best experts to deal with these issues. Oh, yes. And to the extent then that you have that being the quality of the reform, you ought to have carried it to the Law Revision Commission. Mr. Speaker, you know, if it had also now gone to a select committee, I am certain that the lots of benign amendments here would have been supported. But you know what? They do not want it to go there. We went with a hire purchase agreement, bill, and we dealt with it, and it did not have a slow death, as they're saying. No, we came out with the amendments, agreed with some, made some suggestions, and we dealt with all of those only a couple days ago. But you know, they do not want to indicate what is certain mischief afoot in relation to this, in relation to the residency requirement. Mr. Speaker, it is important to understand, as quoted by Honorable Member Sonia Farag, that the Constitution makes certain provisions which it says explicitly that you have to be a citizen of Guyana and you have to be a person who is registered, a citizen and registered, before you can be a voter. Those are explicit. But Article 159 goes on to state a voter should also be one who satisfies such other qualifications as may be prescribed by or under any other law. Any other law in this context for qualification for a voter in Guyana, in all the laws, the Registration Act, the REPA, the Local Government Elections Act, or ROPA, sorry. These, all of them indicate a certain residency requirement. They cannot, I remember, you know, Mr. Speaker, when I was in the PBP with Dr. Jagan fighting for a brand new list in 1990, that the list Dr. Jagan and all of the PBPites were talking about was that it must only have those who are resident in the country. The resident requirement was made the most important pillar for the 1992 elections. Today, you see the PPPites wanting to erase it from our laws. And these people now come and want to say how powerful a law it is. This kind of amendment, and I'm not saying that there aren't positive amendments, it is retrograde when it comes to making the residency requirement be removed. Mr. Speaker, when a law states that, or the Constitution states that other qualifications as may be prescribed by any other law, and knowing that the residency requirement of those who are living here would make that list be wrenched of over 200 and so thousand more names than is possible, it will ensure the kind of purity of the list that is going to ensure that there is no impersonation. The impersonation was proven in a recount process in this same building here. We went through a process and the recount proved that 88 dead people vote. 4,229 or so people who were overseas and never came back voted. The chairman sent to the police commissioner and the chief immigration officer, and we got it. How that happened? Mr. Speaker, it is all part of the report. And that is why I am saying that the Elections Law Amendment Act, which is of 2000, by its section 3 says that wherein instructed by the commissioner to do so, every divisional registrar, either by himself or officers appointed, must by house to house visits within the registration division assigned to him obtain as far as practicable the application for registration of every person who is appointed on the age of 14 years or above for the purpose of ascertaining every person qualified for registration as an elector for election in the National Assembly and is resident in that division. I come to the existing law, and that is why, with all due respect to our Honorable Chief Justice, who made a ruling that the residency requirement is not a requirement under the Constitution. Requirements under the Constitution could come via any other law. And let's understand this. Under the Representation of the People Act, the official list of electors for any division shall be the preliminary list of the electors resident in that division. Resident. Similarly, pursuant to the alteration of the National Registration Act, for the purpose of changing the registered address of any electors resident within Guyana, residency requirement is writ large all over the laws. In Local Government Elections Act, Chapter 2803, Section 10 states very clearly, a person shall be qualified to be registered as a voter for a local authority area, and if not so qualified unless at a qualifying date and so on, that he is ordinarily resident in Guyana within the local government area. And Mr. Speaker, this tirade that it is not constitutional is a hapless argument. Because the Constitution says, effectively, as I just read, any other law that prescribe the qualifications thereto. So you have to be a citizen, you got to get registered and satisfy such other qualifications as any other law provide. And that law is in all of our National Registration Act, our Local Government Elections Act, our and also our Representation of the People Amendment Act. There is, Mr. Speaker, I want to say when such a kind of a requirement is made in another law, that qualification that is prescribed there under that law, as is in 159(2) of the Constitution, that requirement of residency must be elevated from the status of ordinary law to a constitutional requirement. And I'll give you an example, because I argued in the CCJ on this matter. Our Constitution gives us a right to property. Right to property. And in our statutes, they say that if you squat on a land for 12 years, you can prescribe on that property and you can get it 12 years. Assuming we in Parliament now goes and change that law that you can't prescribe for 12 years, you must prescribe for 3 years and you could get another man's transported property. The requirement can't just be changed as the Honorable Attorney General wants it here. This residency requirement is a core value. And you know, we are now saying that we're going to take out residency requirement. When you take out residency requirement like that, you are like taking away from the right to property, reducing 12 years to 3 years prescription. And it is very retrograde, and I want to make sure that we must not go there. Mr. Speaker, this is very important because what the Honorable Attorney General is trying to do here by taking out the residency requirement. And let me say this, even if you feel that the Honorable Attorney General, and we have to be respectful here, has made that ruling, in view of the fact that you want a list that is going to be without bloat and the need for biometrics when you're voting, you can make a law, an elections amendment law, that says that the residency requirement now is part and parcel of the requirement for criteria as for a voter. You can do that. And so right now, we've gone back to a 2001 situation, and we know from the facts that we've been getting from the International Organization on Migration and the diaspora, that Guyana is the biggest diaspora population in any other country. So a lot of us Guyanese are going away. And they're not coming back, but they're going to be on our voters list as if the residency requirement is not a requirement. The Constitution never indicated, Mr. Speaker, that if you're not resident here, that you can't be excluded. Because we're going to have a bloated list. Year after year, as 20,000 Guyanese more go away, because they're going away at the rate of about 20,000, our list will still have them, and it will not reflect a cleansed, pure list for which, indeed, we can go to an elections and find it acceptable. So it is the other extreme. People might have tried other things before, but now it is this list that's going to be the bugbear of unacceptability here in any elections to come. And that is probably what they want. Mr. Ben don't want us to run because the list will be so bloated and the potential for impersonation to the tune like what happened the last elections. 4,800, 200 and something. And this is what we must learn to get away from. We cannot, in the evolving society, as was stated by Mr. Sanjeev Dattadin, evolve into something that is highly irregular. If we are going to have democracy being enhanced, your voters list must be a list that reflects those people who are in and around the country. And we are not disenfranchising those who are overseas. It is when the elections or the qualifying date comes around, they can come back and get registered. But there is no right that if you leave the country and you're gone, just like how if you leave the country and you can't be president, you cannot allow that kind of qualification. It is important, Mr. Speaker. I want you, Mr. Speaker, to understand that in paragraph 139 of the learned Chief Justice judgment, she made this statement: there are no laws setting out any additional requirements, more particularly residency, in relation to a person qualifying to be a registered voter. And section 62A of the elections laws has it. Section 9.2 of the Representation Act has it. Section 11.2 of the Registration Act has it. And to go and make, that is why, after reading the decision of the learned Chief Justice, and with all due respect, I must say that it was somewhat, we lawyers call it, per incurium. Meaning, it is obvious that there was an oversighting of that residency requirement and a proper interpretation of that article, which says that apart from being 18 years and over, apart from being a citizen, such other qualifications as may be prescribed under any other law. The other law all over the place. Mr. Speaker, we must be very concerned not only of what is called this disparity, as it were. We must adhere to the laws. And I noticed just now, after an elections litigation was brought against GCOM, quickly you had Mr. Vishnu Prasad indicating that I will correct myself. And now we got to go and do a 14-day periods of claims and objections. Yes, exactly, because now it has been brought to his attention. I am bringing this to your attention, that indeed there is a residency. Yes, well, fine. Even if it was not appealed to the Court of Appeal, we here, knowing that we do not want a list that is bloated, we want a list like what Jagan would have called for in 92. It must be pure. Then you should have put in back that which is not clear. And that is the residency requirement. Because we are going to have a scenario where so many people can take advantage of the bloat, as we saw in the last recount. And it is so, that part of it, if I may say, in both of these bills that were brought here, was not emphasized. If you look at the explanatory memorandum of the Representation of the People Amendment Bill, it goes straight to section 2, and it never mentions the fact that you have what is called a residency requirement inside of the principal act that is being amended. They seem to want to do it by stealth. They want to do it and ambush us by not putting it in the explanatory memorandum that they are changing resident. And listen to me, this is what they did here. In subsection, in the amendment, in subsection 3, this is section 2, it says in subsection 3, in the opening part, for the word resident, substitute this word with registered addresses. Yes. And they go on to state in the new part, comprising new sections 33A, at 33A6, if the commission so directs by order, notwithstanding anything contained in any other written law, the list of electors to choose the members of any local democratic organ or other local government authority shall consist of names extracted from the official list of electors prepared under this section and registered with an address in the area of local democratic organ. You know what the original act has? Who is a resident of the local democratic organ. They are now deleting that serious pillar that is now going to make all our voters list now be questionable. Mr. Speaker, that is not right. It is not right. And when you go to the other amendment, the National Registration Amendment Bill, they seek now to take away in section 6, the application for registration of any person eligible therefore with an address at the date of his application within the registration division. You know what the original act has? Subject to subsection 3, such order shall apply to all persons who are resident in Guyana. This residency requirement, as I said, is writ large in all our Constitution makes the provision that not only 18 years are registered, but such qualification as is by any other prescribed law. And this is a prescribed law. Local government one is a prescribed law. Representation of the People Act is a prescribed law. And so then, Mr. Speaker, it is important. I will tell you this, Mr. Speaker. A lot of these amendments, you carry them to the select committee, a lot of them will be supported. But this one here is the big setup for some very nasty things that can happen in future elections by impersonation, as we found in the recount. That is what is going to happen. And that is why, Mr. Speaker, we have a regime now that is being presented by virtue of the deletion of the residency requirement that is fundamental, that is fundamentally wrong. It is fundamentally wrong. Let me just state, when the Local Government Elections Act, Chapter 2803, states this: ordinarily resident are the people who should be the voters, the ordinarily resident. And then it goes on to state what is ordinary resident mean. The question whether a person is or is ordinarily resident at any material time or during any material period shall be determined by reference to all facts of the case. The place of ordinary residence is generally that which he has always been, the place of his habitation. Place of his habitation. So if the man living over in America, he's not having habitation characteristics here in Guyana, so he can't be on the list, because you have to be a resident of Guyana inside of a local government area. And now you know what they're going to do for the local government list, Mr. Speaker? The official list that you would normally use for national elections, which is based on so much bloated names of people overseas, they now don't want to correct. They are saying that we're going to give you a power, like it is like an option. The power, if the commission so directs by order, anything contained in any other written law, notwithstanding, anything contained in any other law, the list of electors or other local government authority shall consist of names extracted from the official list of electors prepared under this section and registered with an address, not resident. So you have now this GCOM getting a humongous amount of power for local government elections, contrary to the residency requirement. Notwithstanding any other law, this GCOM now can say, well, or we are going to go and say, deem this act, or deem this list of voters the thing. Mr. Speaker, this thing is retrograde. This thing is disastrous for this country. Because if you do not have a proper list, just like when the Jagans had wanted a list for the 92 elections and the PPP, and I remember the famous book that Janet Jagan had written, Crooked Like a Barbed Wire. The list does not have, the list got too much of people who are not supposed to be there. You remember that, Mr. Speaker? Thank you. Crooked as a barbed wire. And so we now have what is called a coming back to that extreme position of by law now having a barbed wire kind of arrangement. Janet probably turning into grave now because you have a scenario whereby you're going to utilize a list that is going to be even more bloated. The list in 1992 was about 200,000. This list got people who are not resident here to the tune of about 200,000. And so what? It is important because it will halt impersonation, the possibility or the probability of it. And so it is important then, Mr. Speaker, that this bill as it is be sent to a select committee or for the purposes of clearing up some of these issues. And not because of the ruling of the Chief Justice. We can now put back into the act in very explicit terms. We could also put back a requirement of residency because we're going to have huge problems here. Big problems. Mr. Speaker, I only the other day had this is, and you know, in the Esther Pereira case, we were arguing exactly that the PPP, Ralph Ramkaran, Senior Counsel, myself, all of us were arguing that because the voter ID card was a law that prescribed new qualification. Yes, yeah, and but the PPP was arguing that. Oh my God.
Honorable member, for you to continue not arguing but contributing, you'll need an extension.
I rise to request 5 minutes for the honorable member.
Thank you, honorable member. You may continue, but please address the chair.
Mr. Speaker, the biometrics that is required and is not being argued for by the government side makes me make the deduction that they don't want to halt impersonations. If you feel, and we give you all a lot of oil money, yes, this government got a lot of oil money because we signed a rotten deal that you're collecting billions for. You can't have 2,000 biometrics that are going to deal with your fingerprints at the place of poll to stop the impersonation we saw in the recount. 4,000 people that were 4,200 and something people who were not supposed to be in Guyana voted. 88 dead people voted. And so you only want your narrative. You only wanted narrative. Yes, that is what that is what the recount report stated. And that is why the narrative as to that recount is nothing, is something that you try to avoid. You eschew all the time, but you come to your narrative, which probably have some authenticity, but your narrative excludes a very big part of that election, which is the recount process. Mr. Speaker, I am urging that we understand the context in which that the residency requirement is. We must appreciate that indeed that it is a fundamental to any elections, especially a voters list, that you must be resident. And you do not go and extrapolate and say that as a result of the Chief Justice decision, we are now going to say that we are going to have a padded list over 200,000. This thing shouldn't be supported here, Mr. Speaker. It should not be supported because there is an underlying piece of mischief that has not been cured, notwithstanding 5 months of that elections coming out with certain things that indicated impersonation. So we're going to go to the other extreme. We are going to go now to the other extreme. And I am urging, Mr. Speaker, that there has a change of heart. Put this thing in a select committee so that we can clarify all those points and make a list, whether it is going to be for local government elections or regional and democratic elections or national elections or presidential elections, that will be one that will find acceptability from all the parties that will be doing the contestation. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Member. And now for the Honorable Member, Mr. Zulfikar Mustafa, Honorable Minister of Agriculture.
Thank you very much, Mr. Speaker. And Mr. Speaker, I rise to support this piece of important legislation that have been brought to the House by the Attorney General. And Mr. Speaker, we remember the first address to this Parliament by His Excellency the President. He made it very clear that his government will spare no effort to ensure that never in our history of our great nation will there be dishonesty which took place during those elections be allowed to repeat it. And Mr. Speaker, we are hearing tonight about impersonation. We are hearing tonight about all kinds of skullduggery that took place in the last election. And I want to just address a few concerns that were raised by Honorable Member Kemaraj Ramjatan and some of his colleagues. Mr. Speaker, first of all, there were 2,239 polling stations across this country. We in the People's Progressive Party Civic received 2,239 statements of poll signed by all the agents who were represented political parties, including the AFC, APNU AFC. And there was not one single case where there was any objection about impersonation. And today, Mr. Speaker, Mr. Speaker, after 2 years, we are hearing senior member of the APNU AFC coming to this Parliament accusing their polling agent of being part and parcel of impersonation. That is the thanks they are giving to their polling agents. Mr. Speaker, as stated by the Attorney General, we have a mechanism at these polling stations where a voter enters polling station, his ID is being examined against the folio to certify that that's the person. Then they are being taken to the another election official, check all the other particulars, and then given a ballot to be voted. The polling agents is then given the ID card to check if that is the correct person that have voted when they're coming out of the polling station. And I am telling you this evening that there was not a single case that the APNU AFC polling agent object to in the 2020 general and regional election. So I don't know what kind of report the honorable member is talking about, Mr. Speaker. Mr. Speaker, and then the honorable member come here this evening talking about residency. When that matter was heard in the court, And the Chief Justice ruled that residency is not a requirement for registration. Mr. Speaker, our Constitution provides that Commonwealth citizens living in Guyana for 1 year, they are qualified to be a voter and register on the voter roll. And the APNU-AFC wants to deny the people who born in Guyana their constitutional right to vote in our country. We in the People's Progressive Party respect the Constitution. Remember, just during your term in office, 18 names were submitted by the leader of the opposition to pick a chairman of the Elections Commission, and you all went outside of that and picked an illegal chairman that had to go to the CCJ, and the CCJ ruled that that was unconstitutional action by the government. So the APNU-AFC used, and they know how to flout this constitution. You heard the honorable member was talking just now about the Esther Pereira matter. You agree, you came to the parliament. You agree that they need a voter ID card. And when they lose the election, when they lost the election, they went to the court and take that matter that they never agreed to it. Unanimously. So those are the kind of events that are associated with the APNU-AFC. And then we heard the honorable member he just left, Honorable Rizal Ford, said that in this act, there are mechanism and regime that is self-serving. Up to now, I am waiting to hear one of it that is self-serving. One of it. He never mentioned just rabble-rouse and talk about impersonation, talk about division of regions 3, 4, and 6, talk about residency, and those things. Never went into this document and highlight one clause or one section that is against or that will put the election in dispute. This here will strengthen the process. And I will go and highlight some of the issues that we had in the 2020 election and the issues that were condoned by the APNU-AFC, who gave official in GCOM, who gave their encouragement to flout the Constitution and disenfranchise thousands of Guyanese. Mr. Speaker, as I said, the ROPA that we had before this act is totally silent on actions that have been taken by GCOM Secretariat without any legal cover whatsoever. Further, Mr. Speaker, there have been clear cases where provision of the ROPA has been deliberately observed in the breach. Example, a certain the vote cast for each list of candidates by the District 4 returning officer. And we know what took place. We know how many names, how many voters, or how many votes were put to cast aside by the Chief Election Officer. Another glaring example, Mr. Speaker, is the transmission of statement of poll from polling station to returning officer, and returning officers opening the designated envelope containing statement of poll. Mr. Speaker, it is as a result of the undertaking given by the President during his inaugural address that we are here today to debate the identified crucial legislative requirement which all members, if they are concerned with free, fair, and transparent election, will support in this honorable House here tonight. Against this, Mr. Speaker, I will now deal with some specific issues that happened in the last election. Statement of poll, Mr. Speaker. Mr. Speaker, it is public fact that the Guyana Elections Commission, and if our memory is short, let us listen, declare that fake statement of poll for the 2015 general and regional election had found its way into the GCOM system. We all remember that. Mr. Speaker, we in the PPP Civic are not aware of any effort that GCOM made to investigate how this occurred and who was responsible. Moreover, Mr. Speaker, GCOM itself has never since then even attempt to put legal procedure in place to prevent any recurrence. And the 2015 election saw the APNU AFC accede to government. And you never had an interest to investigate and say where was the statement of poll, the fake statement of poll came from, how it went into the system. We had Honorable Member Robson Ben talk about the 21 boxes that we asked for in 2015 to be recounted. It was never given us. But at that time, the APNU AFC, after 2 years, you can show your statement of poll in the 2020 election. But just after 2 days in the 2015 election, you had your statement of poll. Walking about with it, say you won the elections in 2015. Mr. Speaker, in this bill, you will find a comprehensive set of proposed measures which are aimed specifically at preventing manipulation of the statement of poll, as was done in 2015. With the approval of this bill, legislation will be provided for the serial numbering of statement of poll forms in similar manner as the case with the ballot paper. Mr. Speaker, we have proposed in this bill that the templates for the statement of poll forms, like ballot paper, must be encrypted and sent by email to overseas printer. Because there was a lot of these things going with people to the printer by themselves to be printed, with the relevant established technical and security instructions to prevent the template from falling into the wrong hands. What took place in 2015. Mr. Speaker, depending on the number of parties contesting the election, only the required number of copies of statements of poll forms plus 5% must be printed. And that is in this ROPA. Also, Mr. Speaker, depending on the number of parties contesting the election, only the required number of statements of poll form must be given to the presiding officer in charge of the respective polling station. Those are measures that will strengthen our election system in this country. But I didn't heard any one of you mention these measures. Mr. Speaker, in this bill also, we have proposed that all extra statement of poll form must be kept in a secure custody of the respective returning officers. Additionally, Mr. Speaker, statement of poll forms that may be requested as a result of damage must be provided by the returning officer via the relevant deputy returning officer. The damage statement of poll forms must be returned to the returning officer before the replacements are uplifted. And all those are here. If you go through and you read this, all the clauses. And I want to commend the Attorney General and the consultation that took place. You had your chance. You came here and you walked out and left without making a contribution. Mr. Speaker, there will now be legal provision for all used and unused statement of poll form to be accounted for by the POs and the returning officer respectively. This will be done on a statement of poll account form similar to the ballot paper account form and will be used in the same manner as the ballot paper account form. Mr. Speaker, party agents will at all times be involved in the procedure pertaining to receipt, storage, allocation, usage, and accounting for statement of poll forms, as in the case of ballot paper and other sensitive material. To ensure that there are no fake statement of poll, and to ensure that such an illegality never occurs again, we have proposed that these safeguards, which no member of any political party or civil society grouping should find objectable. Mr. Speaker, you recall that the APNU AFC praises the manner in which the election was conducted in March of 2020. They claimed victory and they said that the election was free, fair, and transparent. And if you go back on the record, you'll see the former Attorney General was praising the election in his vehicle, saying that the election was free and fair and transparent. They won the election. Very shortly after the election day, the coalition has declared that they have won the election. But that claim was a falsehood, and thereafter, we all became aware of the APNU-AFC, the rigmarole that took place up to August 2020 to prevent the real result of those elections from being officially declared. Mr. Speaker, during the CARICOM team supervised recount of the ballot, we began hearing accusation of the PPPC that the PPPC had rigged the elections by somehow falsifying voting by dead people and by persons who were overseas on election day. And they have made that claim just now. No report was received from any contesting party on election day that any such malpractice has taken place. The only way something like that could have happened was if the party agent for the APNU-AFC was sleeping or left the polling station. And they claim that they have polling agent at all the polling stations. And we have statement of poll signed by their polling agents. It is for this specific reason, Mr. Speaker, and to ensure that party agents are always present at containers to witness to the movement of ballot boxes and admin bags for containers to the polling station, this bill proposes the appointment and accreditation of alternate polling agents for every single polling station. So every single polling station now will have a polling agent and an alternate polling agent. Mr. Speaker, this proposed safeguard seeks to ensure that contesting political parties have the right to appoint 2 polling agents to each polling station to alternately, as might be necessary, observe all polling day activities, commencing with the movement of the ballot boxes on the morning of election day, from their point of storage right up to the delivery of all statement of poll to the respective returning officer. I don't want to go into the division of Region 3, 4, and 6. The AG and other members have dealt with those, and I think this will help us because we remember, and I think Honorable Member Sanjeev Dattadin would have alluded to the fact that the returning officer for Region 4 faked heart attack. Then you had people move away with the flash drive and a number of other issues. This will help us to conduct the election in a more manageable way, and the results will be in more forthcoming. Mr. Speaker, it is also proposed that each of the 4 sub-districts be managed by the supernumerary returning officer charged with the tabulation of the election result for the respective sub-district. Mr. Speaker, in recognition of the numerous loopholes within the process, counting of the votes at the polling station, transmission of the statement of poll from respective polling station to returning officer, and tabulation of vote cast by returning officer, we have made provision in this legislation to safeguard all those processes. This bill proposes a regime of safeguards which are all aimed at making the procedure more robust, as well as eliminating all existing room for manipulation for different motives. One such safeguard, Mr. Speaker, will be the mandatory requirement for returning officer to make adequate provision for all persons who are authorized to be there to witness the tabulation of the result using the actual statement of poll, while the progressive tabulation will be displayed on a screen for the benefit of all concerned. So as Honorable Member Sanjeev said, that there will be no more need for spreadsheet and bedsheet arrangement. Mr. Speaker, in recognition to the security checks and balances which currently exist in the ROPA, this bill proposes a series of step-by-step procedure intended to strengthen the above-listed procedure and guarantee the integrity of the result of the elections, which are tabulated by the returning officer. Mr. Speaker, transparency is one of the hallmarks among the established international standard for the conduct of election. However, Mr. Speaker, apparently this was not done by the former chief election officer who refused to show the copy of the statement of poll. given the manner in which District 4 returning officer did his tabulation and made falsified declaration of the result. In fact, Mr. Speaker, the former GCOM CEO made his own tabulation, which varied considerably from the result declared by the returning officer, and still refused to show the statement of poll which he have got in his figure. Then, Mr. Speaker, we heard excuses like the CEO is the lawful custodian of the statement of poll, and that he is not obliged to show them to anyone. It took a court order from the Chief Justice to instruct the CEO to release his copies of the statement of poll. Mr. Speaker, as a nation, we cannot go forward in this scenario, where the laws or lack thereof would allow any GCOM CEO to withhold a copy of the statement of poll for the entire country. And this is why, Mr. Speaker, to avoid what transpired in 2020, this bill proposes the introduction of legislation which will make it mandatory for the Chief Election Officer to publish all statements of poll by district as he received them. Further, Mr. Speaker, the bill proposes that the CEO will now be specifically authorized to ascertain the result of the election by adding up the result received from the returning officer of the 10 electoral district, which he will be legally required to submit to the Commission for ratification and declaration. Mr. Speaker, these measures are here to strengthen our electoral process. And it's very sad that we are here today to pass this legislation to make our electoral laws more strong, to strengthen the process, and the opposition has just left the chamber. It is very sad because we know for a fact they are not interested in the democracy of our country. From 1964 to 1985, we have had rigged election in our country. From 1992 to 2015, elections were certified as free and fair. And in 2020, we had yet an attempt to rig the election. This here, Mr. Speaker, will help us to never in the history of our country allow another rigged election to take place. With this, Mr. Speaker, I support this legislation. I want to commend it to the House. Thank you very much.
Thank you, Honorable Minister of Agriculture, the Honorable Zulfikar Mustafa, and now for the Honorable Minister of Parliamentary Affairs and Governance, the Honorable Gail Tashir.
Thank you, Mr. Speaker. I know the time is late. I first of all wanted to start by really appreciating the presentations by all my colleagues on this side to deal with what is a historic bill and one that took time, both internally for the government and the PPP with many supporters and civil society organizations to come to this point. But more importantly, at this moment, and just this moment, is really for the Parliament and for those of us who struggled for free and fair elections for a long time, to recognize the passing of Father Malcolm Rodriguez, a Jesuit who fought for free and fair elections in the very difficult days of the 70s and 80s. And so tonight may be, ironic in the sense that we're discussing a bill to do with electoral reform and enhancing the electoral systems to try to prevent the attempt by very evil-minded people in our country to steal an election and to steal the people's rights to choose who they wish to have as their government over the 5 years. Mr. Speaker, we have witnessed in this House, I could say disgraceful, and yes, it is disgraceful. I could say I'm embarrassed, and yes, I'm embarrassed. But really, I am horrified by the fact that an opposition comes here, the AP and UFC, to make it distinct from Mr. Schuman's joinder parties, who comes here after a year of a bill being put on Facebook, hard copies sent to all the political parties, and in particular, the request by Mrs. Valda Lawrence as the then chairman of the PNC and the then General Secretary of the PNC, Miss Amna Ali, to request copies of the bills. In November 2021, it is not our fault they had elections in their Congress and they've overturned their party upside down and inside out. But the point is that the consultation process, which they're making fun of today, they're making light of today, is real. The president made a commitment in October that the bills would be available within a week's time. So said, so done. The bill remained on the Facebook. Hard copies were given to anybody who called in. And organizations did submit, although not the kind of response we expected, because we thought that a number of organizations would have been more active. But the Guyana Elections Commission itself, that is the chairman and CEO, put forward their views. The Guyana Consumers Association, the Electoral Reform Group, the Private Sector Commission, the A New and United Guyana, and several persons who lived overseas who wrote comments, etc. And so we had in May the invitations with Attorney General, who consulted with the submissions in writing by the organizations and individuals I called. And what was clear was that a number of the amendments that they were talking about had to do with constitution and not electoral reform in terms of statutes. And that did lead to further amendment in terms of the bill. For example, the one that we've talked about tonight, and that is the comments that instead of just having Region 4 having the subdivisions, have other regions. And in fact, that is how we made the amendment to do with Region 3 and Region 6. This view that came out that the subdivisions was some kind of dastardly plot by the PUPC to disenfranchise and to corrupt the system is a hoax. It's because, in fact, in Region 4, there's always been subdivisions. For East Coast, East Bank, North Georgetown, and South Georgetown. What you're taking is the same apparatus that led to the 4 subdivisions in Region 4 to be able to now manage the count. Region 3 has always had the 3 subdivisions. Region 6 has always had the 3 subdivisions. So nothing was done to in any way overturn the way in which GCOM manages itself. We come here almost a year and a week later from when the bills were first posted, and not one comma, not one colon, not one semicolon, not one word, not a comment from the APNU AFC, who say and claim that they represent 49% of the people of this country. This abnegation of their responsibility as political leaders is horrifying, and one in which their behavior tonight reveals their agenda. Their agenda is not one to cooperate. Their agenda is not one to say, let's have a select committee and let's sort it out. What are we meeting to sort out? You first of all have speakers tonight who've said, we oppose it. It's all this bad plot and this attempt by the PPPC to control the Elections Commission and to overturn this and overturn that. So what are we changing? What is there to meet and talk about? The Amanza Walton Desir talks about a select committee. Mr. Ramjatan and Mr. Ford oppose the bill, but say, and one of them, Ramjatan, says it could go to select committee. Ford doesn't commit himself to that. And Mr. Norton, who I was advised wished to speak and would speak before the Attorney General, suddenly walked out just now. So what kind of political leadership? This bill tonight and these bills to do with electoral reform are very revealing in terms of the opposition behavior. Not surprising, because we've gone through their behavior for decades. We've gone through rigged elections for decades from the 1970s, 60s and 80s, 70s and 80s. But their DNA hasn't changed. They still cannot function in a democratic environment. They cannot function in an environment where they have to play the role of sharing, of compromising, of leading in the best interest of the people of this country. The bills before us are not perfect, but in our whole struggle for democracy, our whole struggle for free and fair elections, and to protect the electoral system of Guyana, we have made changes over and over again. We must never forget that the first universal adult suffrage election in Guyana in 1953, where the PPP won 18 of 24 seats, was overturned by the British with warships and the implanting of an interim government. And from then on, we have had to struggle with gerrymandering of the boundaries in 1964, with the conspiracy of Her Majesty the Queen, now passed, with the Governor General to have Mr. Burnham and Mr. Degas create a coalition, to 1968, what was called the making of a prime minister by the Granada TV, to 1973, Mr. Burnham does it again a Granada TV. 1980, when the electoral report that we did came out calling toothless poodle, which had to do with GCOM being totally incompetent and unable to protect the rights of the people of this country. To 1985, with elections crooked as barbed wire, which came out with the PCD, the Patriotic Coalition for Democracy. So we've been there. We had to fight for the most important thing before the 92 elections, and that was the counting of the votes at the place of poll. And that is what preserves the electoral system in Guyana. You know, they're vexed with Hoyt about that because Hoyt was pressured by Carter and the Belize president and others across the world. And you know, we take for granted this counting the place of poll, but it has saved democracy in 1992, 97, 2001, 2006, 2011. It has saved us in 2020. The counting of the ballots at the place of poll. I was an observer of these British elections in 2016. And we've always had this impression that other people's elections are, you know, more scrutinized and better than ours. And I was sent to Edinburgh. And on the day of elections, whilst you can mail in your votes, they had persons who turned up at the polling station. And they voted manually. There was no electronic voting machine. They voted manually. And then, to my horror, they never counted the votes at the place of poll. That was done by an enormous room where thousands of ballot boxes were coming in. Ballots were thrown on different tables. Scrutineers were standing way back, 30 feet back, and they were counting and shouting the numbers. It was worse than a fish market. And so the appreciation of where we had come as of 2020, and then we have 2020. No legislation can anticipate, I believe, the evilness of man. We cannot. It would be, if we can conceptualize how evil people can be, then maybe we may be becoming evil ourselves. But that the fact that the 2020 experience and the torture and trauma, as my colleague Minister Sonia Parag said, the trauma that the Guyanese people went through for months after months. Forget about before that. that the no confidence motion, we were supposed to have elections in 3 months. We had elections 14 months later, and we had to wait 5 months after that for the declaration. 19 months in the history, in the lifespan of a nation. Unthinkable, unthinkable, unthinkable. It slowed down the country. It impacted on people's lives. It increased poverty. It increased a number of social problems we had. And on top of that, we had COVID. We are here to rectify and to ensure that, and to remedy and to ensure that whatever loopholes, lacunas, and others in the law that existed that allowed the conspirators and those within the GCOM hierarchy and those outside in the former government to conspire to ensure that the will of the people was overturned. These bills try to rectify the entire process from the time you get registered at the age of 14 and your ID card and you get on the voters list at 18 to the allocation of the polling stations, which I just want to mention one aspect of that in the bill, which has been received well, and that is the provision in the law for accessibility of persons with disabilities to be able to vote. And that has been greeted with great aplomb by the organizations representing disabled persons. And we've written it into the law as a consideration that must be protected and recognized in the selection of the polling stations. Mr. Speaker, it is clear from the behavior of the opposition. They have no appetite for electoral reform, and I don't believe they have appetite for constitutional reform either. Well, that too. Thank you, Attorney General. In fact, in the consultation, what was surprising, Mr. Speaker, is that one of the GCOM representatives for the opposition, who was representing a civil society at the meeting, stated very clearly that we were doing things upside down. What we were supposed to do is constitutional reform and then statutory reform. Well, Mr. Speaker, if we're going at the speed at which they would have us go at, you'll never have constitutional reform, and certainly won't get to statutory reform by the time the 2025 elections come. So this is all the agenda of the opposition, is to be obstructionist, to be able to try to mamagai the Guyanese people, and to talk about bloated lists and dead people voting and overseas people voting. I think my colleague, Minister Zulfikar Mustafa, answered it very well. The scrutineers signed the statements of poll, and therefore, if they had conspired with the PPP to allow, and the presiding officers to allow people to vote who were dead, or people who were overseas or not in the country, then obviously the opposition has a bigger problem than we know. But Mr. Speaker, they have raised the issue of residency, and I'm sure my colleague Attorney General will raise it. But we had the experience in 1997 of bringing legislation here that was unanimously supported by everybody for a voter ID card, which was overturned by the court. So the arguments by Mr. Ramjatan about residency and it's in all the electoral laws and therefore we should be doing it, etc., in the face of the Chief Justice ruling, will send us down the same road as the 97 case occurred. And so, Mr. Speaker, we want to make sure that the system, wherever there were opportunities, and to fix some other issues that have been historical. We put into the bill about polling agents accompanying the ballot boxes. This has been an issue from 1973 with the young people who were killed in what was called the ballot box martyrs. So this puts into the law that GCOM provides transportation and or it allows the private vehicles to follow. The issues of the polling agents being able to have the list of the voters, which almost every other station around the country for years, there's always this battle that the polling agent wants to walk out with a list that they've ticked off, and the presiding officer says, no, you can't take it, it's a property of GCOM. These are what you call irritants that have been in the system for a long time. These are being fixed by the legislation, and they give comfort to the polling agents. The issues of the SOPs and the tabulation and ensuring that you don't have to wait for the ballot boxes to come in before you start tabulating the statements of poll. The posting of the statements of poll on the GCOM website and the way in which it's to be handled. These are critical components for transparency and accountability to the Guyanese people, and to give our people assurances that their votes count and that they will not experience what happened in 2020 ever again. We owe the Guyanese people, this as parliamentarians. It's regrettable that the opposition doesn't seem to have that conscience or moral obligation to the Guyanese public. But we on this side of the House have a moral obligation, a constitutional responsibility to protect the right of our people to vote at free and fair elections without interference, without GCOM itself being the organization that's actually undermining the elections. We have to restore trust and confidence in the electoral system. It's our responsibility to do that. And therefore, the opposition will continue to play an obstructionist role. It will continue to find excuse after excuse. It will continue to mix up constitutional reform and statutory reforms. It will continue to cry that they wanted a select committee and we denied them. It will continue to find ways to stall things such as the constitutional appointments of the Public Service Commission, of the Teaching Service Commission. These are and the Judicial Service Commission. They will continue in this vein of obstruction and preventing, and by these means, trying to prevent Guyana from moving forward. Regrettably, they're on the wrong track. They're on the wrong side of history. And the country will continue to move forward. We will continue to build our country. We'll continue to transform our country. We'll continue to enshrine and strengthen the democratic institutions of our country, including GCOM, and we'll continue to build the trust and confidence of our people under one Guyana. Thank you very much, sir.
Thank you very much, Honorable Minister Teixeira. I see on my list as the Leader of the Opposition. Let me just check to ensure that it's not online. Honorable Leader of the Opposition. Honorable Attorney General and Minister of Legal Affairs. Right on the stroke of midnight.
Thank you, Mr. Speaker. Mr. Speaker, I want to thank all my colleagues who, as I said in my opening presentation, would have covered the breadth and amplitude and magnitude of the bill in all its different facets. And they have done so with remarkable clarity and coherence. And I don't believe, in fact, that there is any aspect of the bill that is left unanswered or have not been addressed by the various speakers on our side. Mr. Speaker, on the other side, we have heard presentations, but what have they said? The Honorable Amanza Desir clearly has not read the bill, did not read the bill, and came here expecting to speak and apparently thinking that the honorable member was sound intelligent. I don't know how one can do such a thing. How can one choose voluntarily to speak on a bill, a lawyer at that, knowing full well that you're going to be streaming live and the country and the world will be watching you, and you have not read a sentence in the bill, as was evident in her performance this evening. All the honorable member spoke about was taking the bill to a select committee. A bill that was on the order paper for how long? Nearly 3 weeks, was in public circulation for an entire year. Never chose to read it. Even when it came to the parliament for the past 3 weeks. Even we were here 8 hours before the debate actually began on the bill, did not care to even read one page. Not even one page, but stands there and speaks for 30 minutes, wasting all of our time. And about the quality of water that comes through the tap, and blackout, etc. Mr. Speaker, I hope that the people of Guyana are recognizing, are seeing the type of representation that they are getting from this useless pack of honorable members in this parliament. They are honorable but completely useless. And the people of Guyana must determine how long they will fetch them on their backs. Because if the people determine at the next election that they will not be here, they will not be here. It is the people who will determine, after looking at how they have abandoned the people's business, it is the people to determine whether they want to perpetuate this kind of irresponsibility in this parliament. Mr. Speaker, Mr. Ford spoke, and I am still to decipher whether he supports the bill or whether he doesn't support the bill. Most of his presentation, he paid compliments to the bill and to the staff of the AG office. He has some problems with residency, which I will deal with in due course. But at the end of the presentation, he doesn't support the bill. So it's difficult for one to even address what Mr. Ford says. He has a problem, Mr. Speaker, with Section 33, and I'll read Section 33 because I cannot fathom what the problem is. Section 33A6, it reads this: if the Commission so directs by order, notwithstanding, let me read again. If the Commission so directs by order, notwithstanding anything contained in any other written law, the list of electors to choose the members of any local democratic organ or other local government authority shall consist of the names extracted from the official list of electors prepared under this section and registered with an address in the area of that local democratic organ or local government authority. I don't understand what is his problem with this. All this says is that the GCOM can, by order, extract from the list of electors the list of names that can go to an election for the purpose of a local democratic authority. So you look at the voters list and you extract the names based upon address on the list for the purpose of going to a local government election. What is mystifying about that? That is how lists are extracted. This is not an addition. We are not putting an addition here. We have simply migrated from the Election Laws Amendment Act of 2000, a provision, and situated appropriately where it should be within ROPA. So we have not interfered with the existing law, and there is absolutely nothing wrong with the law in its current construct. As I said, this law has been here since the year 2000. I don't know Rip Van Winkle now, Roysdale 4 discovers it and finds some problem with it. So, Mr. Speaker, I come now because the Honorable Member Comrade Ramjatan spoke at length about residency. So, first of all, let us start with the Constitution, Mr. Speaker. Now, Mr. Ramjatan begins in 1992 and refers to the struggle of the PPP in 92 or approaching the 92 elections to get certain reforms done. Among the reforms was the abolition of overseas voting. That was one of the crucial reforms, sir. I believe you were part of the process that agitated for those reforms. It was against phantom voting that took place overseas. Hence the requirement, if that is the danger, then the emphasis has to be residency within sovereign Guyana. Obviously, Ramjatan doesn't understand that up to now. So the focus at that time was against overseas voting and for the establishment and the ensconcement within the law of a requirement that would ensure that only local voting takes place. And that mechanism was residency. So it was a big thing in the law then. It remained part of the law, Mr. Speaker, until the 1999-2001 constitutional reform process. Mr. Ramjatan was part of that process. If you look at the Constitution, Mr. Speaker, Article 59, which is subject to Article 159, they speak about the qualifications to register and the qualifications to vote. Both, if you read the marginal note, Mr. Speaker, they were amended by a 2001 amendment, Act number 3, and I believe Act number 6 of 2001. It is the constitutional reform that injected into these provisions in the Constitution the removal of any shred of evidence which requires residency. Is that I put it here? It is what the people of Guyana decided in a constitutional reform process and which this parliament unanimously passed. And Mr. Speaker, 159, which is the mother provision, it says this. It says, subject to the, no person shall vote at an election unless he or she is a registered elector. Nothing to do with residency. One sentence. 59 tells you before that. Let me quickly go to 59 to put it on the record. 59 says before that, subject to the provisions of Article 159, every person who may vote at an election, if he or she is of the age of 18 years or upward and is either a citizen of Guyana or a Commonwealth citizen, domiciled and resident in Guyana. The resident there relates to Commonwealth citizen. So, once you are 18 years and upwards and you are a citizen of Guyana, you are qualified to vote. That is further entrenched by 159, which says that no person shall vote at an election unless he or she is registered as an elector. And you can only be registered if you're 18 years and over and you are a citizen of Guyana. It continues, subject to the provision and so on and so on. A person shall be qualified to be registered as an elector for elections if and shall not be so qualified unless on the qualifying date he or she is 18 years or upwards and is either is a citizen of Guyana or is a Commonwealth citizen. resident in Guyana. Where is residency part of the requirement either to register or to vote? And that is what I can't get into their heads, Mr. Speaker. Mr. Speaker, Ramjatan cites this provision. He says that also the Constitution does say satisfies such other qualifications as may be prescribed by or under any law. Now, Mr. Speaker, this is the very provision that put us in problem in 1997. Invoking this very provision to add qualifications, this Parliament unanimously added a voter ID card as a qualification. It was authorized by the Constitution. It was authorized by the Constitution. It was passed by a law, and the Constitution permits it. And it added a requirement. But you know what the judge held? Properly so. The requirement, though the Constitution authorizes, cannot detract from the fundamental right provided for by the provision. In other words, you can't have a section of the law departing and derogating from the pith and substance of the article. And the pith and substance of the article was to protect the right to vote. That was the fundamental right. Everything else in the article was secondary. So when you put in something there that is secondary and that conflicted and affected the performance of the fundamental right took precedence over that one. So you had to read down the secondary one and read up the fundamental one. And it is that canon of interpretation that Mr. Ramjatan can't understand up to now. Similarly, if, as he is advocating, we pass a law and add residency, it will suffer the same fate. Why? Because that fundamental right to vote will now be diluted by a residency requirement. In the same way that the fundamental right to vote was diluted by an ID card requirement. That simple legal logic eludes Mr. Ramjatan. And Ford is no better, he's worse. Mr. Speaker, they speak at length about the Chief Justice's ruling. The Chief Justice ruling did not fall out of the sky, Mr. Speaker. I filed the case to challenge the house-to-house registration process that was started by GCOM under the chairmanship of Patterson. Why did we challenge it? We challenged it that it was part of our legal case that they intended to scrap the National Register of Registrants and to start a new database because they wanted to remove overseas-based Guyanese on that database and only register resident Guyanese on that database. That was the crucial and quintessential question for the court. That was the very question before the court. It was not that the Chief Justice woke up one morning and ruled in abstract. Those were the competing legal arguments, exactly what they're saying here and exactly what I am saying here. They were arguing that residency is a requirement because it is in the Registration Act, because it is in the several pieces of legislation. And the Chief Justice said, no, insofar as you insist on residency, you are colliding with the Constitution, because the Constitution only lists two requirements: citizenship and adulthood. So, Mr. Speaker, insofar as all the legislation to which Mr. Ramjatan made reference speaks to residency as part of the electoral equation of this country, they are all unconstitutional. That is the ratio decidendi of the Chief Justice's ruling. The Chief Justice only declared one. We need to take all to court and have them declared unlawful. What we are doing here now, Mr. Speaker, as I said in the beginning of my presentation, is to get all the scattered pieces, sterilize them of their constitutional impurities, and then add the reform to them. And that is what we have done here, Mr. Speaker. And that is why we have removed residency. It has no place until we change the constitution, if we wish to make residency a formula, an equation in the formula. We have to change the constitution, or else we have to change all the laws, because all the laws must conform to the constitution. And that is why, Mr. Speaker, residency has been removed and replaced with an address at a particular location. So you can have an address. You don't have to be resident there. You can have an address at my parents who live in the United States of America. They have an address at 69 Narayan Street, Annandale. When GCOM staff goes there, they must go and verify that that is their address, not their place of residence. It is their address. And that is what GCOM must put in their system now to become compliant with the Constitution. And when you go to verify, you're not verifying the existence of residency. You're going to verify the existence of that address. That there's a house there, that the address exists. That is what the law says now. That is what the Constitution says since 2001. That is all. That is what the Constitution says. If we do anything other than that, we would be derogating and violating the Constitution, Mr. Speaker. So Mr. Ramjatan was asking the question, or Mr. Ford, how do you go and verify a person's address or that he's living there? All you have to go and verify is that that address is not fictional, and perhaps somebody can say, yes, I know that person is using this address. That is all that our Constitution requires. And there is no magic in that, Mr. Speaker. Nobody can get disenfranchised because of that. You have that address, and that address is where you'll be voting at national elections, and when local government elections come, whichever constituency you fall into, you'll be voting from that address or using that address as a base, and you will find your place on the electoral list. What is mystifying about that? What is confusing about that? So, Mr. Speaker, this whole, I don't want to say diatribe, but this whole argumentation that we have been hearing tonight about residency and this SCIF, I am surprised that Ramjatan, an experienced lawyer, can't appreciate what the Constitution says and how the law must be refashioned to suit the Constitution. Ramjatan has the thing the opposite way around. Ramjatan wants us to refashion the Constitution to suit the law. That is putting the cart before the horse, Mr. Speaker. It is the law that must be brought in conformity with the Constitution, not the other way around. So, Mr. Speaker, no one has really put forward on the other side any serious argumentation about this bill. So, there is very little to answer, because I've answered what they have raised. Mr. Ford raised this argument without even developing it. He says that we have chosen 3 regions and we are subdividing them. The reason why we chose the 3 regions, we started in Region 4. They objected, Mr. Speaker. They said that we are targeting their stronghold. And we choose 2 other regions because of their populous nature. That is why we chose 3 regions. It doesn't create any disadvantage over the other regions. The other regions don't have this number of votes to count. We chose the 3 regions because they are 3 most populous voting regions in the country. It is as simple as that. And there is no other advantage or disadvantage that is created. All that will happen is that the votes will be tabulated in different parts of the polling district. That is all that will happen. And you will have different aggregates, the count will be quicker, and you will have smoother results. You would not have this skullduggery of Mingo. Last thing, Mr. Ramjitan keep repeating that discredited narrative about phantom voting and voting impersonation, etc. The same nonsense that they said before the CARICOM audit team. I just read the CARICOM observer team report. First of all, they selected that team. You remember they put out all the other observers. They chased Carter Center out of the country. They didn't give them permission to come back in. They did not permit any other observer team. President Granger said the CARICOM observer team was the most legitimate interlocutor. I remember those words. And they appointed the CARICOM team. When the CARICOM team gave them the shaft, they're bawling. The CARICOM team said to them that they looked at their allegations of irregularities, and it all was a fishing expedition. That's the exact words. And that they cast the net so wide that the picking was very slim. I'm quoting from the CARICOM report here, Mr. Speaker. That their allegations were incredible and incredulous. Those are two words I also remember from the CARICOM report. So, and then they got an opportunity to go and challenge the elections in the court to prove all the 75,000 zombies that voted and all the impersonating that happened. They had an opportunity. The law gave them an opportunity to go to the court, file an election petition, and litigate your matter. Bring all the witnesses that you have to say you see 75,000 zombie voted. You know what? One petition was not served properly, and that was dismissed, and the other one was dismissed on points of law. So who is it they want to blame for that? They're blaming us that we shouldn't win the case. We should allow the case to go to trial. You file a case, you can't even serve it right. And the man who they misserve, or they short serve, or they didn't serve, was their own leader. Now, if they had misserved Comrade Bharat Jagdeo, he had hid from them and so on, he accepted service the first day. It is David Granger that they had a problem serving. You know, if they had a problem serving Vishnu Bandhu, a party in the action, or anybody else, even Lowenfield, you know, you had an explanation. They couldn't find their own leader. Their own leader. And they come here to blame the world about losing the elections. So, Mr. Speaker, this is a very important bill. I know the hour, and I ask, Mr. Speaker, that the bill be read a third time. Thank you very much, and passed.
I think you might be premature in the third time. You asked that the bill be read a second time. Honorable members, this concludes the debate on Bill number 24 of 2022, Representation of the People Amendment Bill 2022. I now put a question that the bill be read a second time. Those in favor say aye.
Aye.
Those against say no. Ayes have it. Let the bill be read a second time.
Representation of the People Amendment Bill 2022, Bill number 24 of 2022.
The House will now resolve itself into committee to consider the clauses and the schedule of the bill. Honorable members, we have a bill with 4 clauses and a schedule. And I propose that clauses 1 to 4 and the schedule of Bill number 24 of 2022, Representation of the People Amendment Bill 2022. I propose a question that the bill be considered in committee. Honorable members, I propose that this clause and the schedule stand part of the bill. Honorable members, I now put the question that clauses 1 to 4 and the schedule of Bill number 24 of 2022, Representation of the People Amendment Bill 2022, that the clauses stand and the schedule stand part of the bill. Those in favor say aye.
Aye.
Those against say no. Ayes have it. I now put the question that the bill as presented be reported to the Assembly. Those in favor say aye.
Aye.
Those against say no. Ayes have it. Let the Assembly resume. Honorable Attorney General and Minister of Legal Affairs.
Thank you, Mr. Speaker. I rise to report that the Representation of the People Amendment Bill 2022, Bill number 24 of 2022, was considered in committee clause by clause and was passed without amendments. I move, Mr. Speaker, that the bill be now read the third time and passed as printed.
Honorable members, the question is that Bill number 24 of 2022, Representation of the People Amendment Bill 2022, be read a third time and pass as printed. Those in favor say aye.
Aye.
Those against say no. Ayes have it. Let the bill be read a third time.
Representation of the People Amendment Bill 2022, Bill number 24 of 2022.
Thank you. Honorable members, we will now proceed with the second reading of the National Registration Amendment Bill 2022, Bill number 23 of 2022, published on the 1st of November 2022. Honorable Attorney General and Minister of Legal Affairs.
Thank you, Mr. Speaker. This bill accompanies the ROPA Amendment Bill, and Mr. Speaker, it completes a cycle of amendments in relation to our election system. Mr. Speaker, as is well known, registration of electors, registration of citizens, and the electoral process are all connected. And Mr. Speaker, like the ROPA, there were scattered amendments all over, which we had to accumulate and put them together here. What this bill seeks to do generally, Mr. Speaker, is to, first of all, strengthen and clarify the concept of a continuous registration system, which is this registration system provided for by our law. That's the first thing. There are sections there in the law that can create some kind of doubt, and that is why there is an argument continuously made for house-to-house registration. House-to-house registration cannot take place in the face of a cyclical continuous registration system. This cycle continues by operation of law. It is now being clarified, and also fixed intervals are being dealt with here, so that it's not left to GCOM to determine by order when they will start a cycle and when they will stop a cycle. we are now fixing in the law that there are going to be 2 cycles per year of continuous registration. Importantly, Mr. Speaker, we are creating a new regime of directives for the Chief Registration Officer, who is also the Chief Elections Officer, to comply with, to ensure that registration is disengaged, as a civic system is disengaged from registration for the purpose of elections. Because in Guyana, we seem to conflate the two, and it causes untold problems by that unnecessary confusion. They are different processes. Citizens, once they become of registrable age, they must register. Once they register, they must be given their ID cards upon registration. This has nothing to do with elections. When election, however, the cycle continues, and every 6 months, that registration goes over, that there's a break, there's a 1 month period, and then the numbers are extrapolated and put on a register. And then the cycle continues again for another 6 months. It breaks for a month, and names are transferred over again. Once they become aged to be put on a list. It is that list, Mr. Speaker, that will eventually become the voter list. Why that system is there now? Because, Mr. Speaker, at any given time, within a 6 months notification period, in fact, 3 months notification period, one can have an election list ready. And this is going on independently of ID cards being issued all the time. And there's a duty imposed now for ID cards to be continuously issued upon registration. So one doesn't have to wait and line up election time only to get one's ID card. That system is being broken up, and it is clear guidelines are now provided for when ID cards are to be issued, and the cycle of registration. It begins, Mr. Speaker, from January to May, with a qualifying date of 30th of June, and during the month of July to November with a qualifying date of 31st of December. And that will not stop. GCOM has nothing to do with that. GCOM must carry out this. This is the cycle that the law is creating now, and this will not stop. So that hopefully will clear the air forever. If you want to stop this and you want house-to-house registration, we have to come back here and amend the law. Amend the law, and then we'll have to deal with the legal consequences, because what are you going to do with the database? You already have a ruling from the court that you can't throw away the database. So I don't know what purpose you will go to house-to-house registration for. Mr. Speaker, as I said before, there is removal across the board of any residency requirement anywhere. And the language used to substitute is an address. An address at some locality, or an address in Guyana. That satisfies the constitutional position. An address. You don't have to be resident there, but you must have an address there. And there's the verification process, which I've spoken about. It is provided for here. You can do your change of address, etc. The person will go and verify where your new address is. It has nothing to do with whether you're a resident at that address or not. You don't have to be. And of course, we're creating list of offenses as we are going on, as we're going through with each new requirements that we are now establishing in the law. Mr. Speaker, then we have the troublesome matter of debts. So we agree, Mr. Speaker, that dead people ought not to be on the list. Under the Constitution, they are disqualified and they must be removed. Unfortunately, it would appear that they have not been removed at periodic intervals from the list. That's the report out there. I don't know. I never checked it. What we are doing, Mr. Speaker, now is to make it mandatory for the registrar of deaths to furnish to the chief registration officer a list of dead people every 4 months and the requisite information confirming those deaths. So every 4 months, a list would come from the registrar of deaths to the chief registration officer of the persons whose deaths are recorded at that department. So that more than 90% of the deaths in Guyana, as far as I am aware, are recorded. So that should take care of about 90% of the dead people or persons dying within the country. If that mechanism is not complied with, again, there's an offense created. So that's one issue to deal with. Recorded deaths. How do we capture unrecorded deaths? The bill establishes a mechanism that brings together the chief medical officer and the police commissioner. And they must send to the chief registration officer deaths that come within their knowledge every 4 months as well. Deaths that are not on the register at the births and deaths office. So this is another net that we are creating that would hopefully capture unregistered deaths. So the chief medical officer will have to now create a network among the medical institutions of the country to collect data of persons dying in the system. The police force has its current mechanism already uplifting that data within the police system. These two statutory officers now will have to play a role in furnishing the information to the chief registration officer. The chief registration officer now, when he receives that information, because it's not confirmed, he must now carry out a process. He must send it to his divisional offices across the country where the person would have died or where the person may have been living. And when the claims and objections will take place in that locality, those names will be part of the claims and objection period, and it will be published that these are persons who are believed to be dead because their deaths are unconfirmed. If there is no objection and no one can confirm or dispute that the persons are dead, only then their names will be deleted from the register, from the national database. Mr. Speaker, we believe that the combination of these two initiatives will cleanse the voters list and the national database of over 95% of dead persons in the country. And that is all that we can do at this point in time. I don't know of what other mechanism. We asked at all the consultations for another mechanism to be suggested, and none came forward. Some persons are raising issues about if you die overseas, what will happen, and you're still on the list. Well, we don't have a mechanism in place to deal with overseas deaths. We don't have that type of infrastructure in our diaspora that will send that kind of data to us here in Guyana. Until such an infrastructure is established, we have to continue the way that it is. If someone has a better idea, we are still open. Nobody has come forward. And of course, Mr. Speaker, I spoke about the ID card, etc. And let me just dwell a bit about that biometrics. Now, a lot has been said about biometrics this evening. And it is shocking the misunderstanding and the ignorance that passes in this parliament. Biometrics, on the other side, means electronic voting. You realize that, right? They are equating biometrics with electronic voting. Concepts are not understood in this place. Mr. Speaker, I want to put on the record that we have biometrics in our electoral system. When you register, Mr. Speaker, you have to give your date of birth. They check your eyes, they check your height, they check your color, they check your distinguishing marks. All of those things are biometrics. But fingerprints, all that is what constitutes your biometrics. And they are put on a registration card. It is the information on that registration card when you are registered that goes into the national ID card. And it is that registration card essentially that is kept and converted to that folio. And that is why at that polling station, your folio and your ID card coincide. They come from the same source and they contain your biographic and biometric data. Electronic voting is a mechanism for voting. It got nothing to do with biometrics. Big educated people I'm listening in this parliament conflating and confusing separate and distinct concepts, and they have the innocent population listening to them. You might read tomorrow in the newspaper, PPP reject biometrics. Opposition calls for biometrics. And Ramjatan said, all we need is 2,000 electronic voting machines. And that is what he called biometrics. Mr. Speaker, it's going on now to the morning. I ask Mr. Speaker that the bill be read a second time. Thank you.
Any other contributors? Deputy Speaker? We have a number of members online. Let me just check. Honorable Attorney General, there being no other contributor, you have an opportunity to close again.
I wouldn't thank myself, Mr. Speaker, but I will say, Mr. Speaker, that I ask that the bill be read a third time?
A second time.
A second time, sorry. Second time.
Yes. You proposed a few minutes ago. Honorable members, the question is that Bill number 23 of 2022, National Registration Amendment Bill 2022, be read a second time. And I put the question. Those in favor say aye.
Aye.
Those against say no. Ayes have it. Let the bill be read a second time.
National Registration Amendment Bill 2022, Bill number 23 of 2022.
The House will resolve itself into committee to consider the clauses and the schedule of the bill. Honorable members, the National Registration Amendment Bill 2022, Bill number 23 of 2022, has 4 clauses and 1 schedule. I propose that clauses 1 to 4 and the schedule form part of the bill. Honorable members, I now put the question that clauses 1 to 4 and the schedule of Bill number 23 of 2022, the National Registration Amendment Bill 2022, be passed as proposed. And I now put that question. Sorry, not passed. Be adopted. It's that time of the morning. Those in favor say aye. Those against say no. Ayes have it. Honorable member, sorry, I put the wrong I now put the question first that clauses 1 to 4 and the schedule, just that we don't get a court challenge, Honorable Attorney General. I put the question that clauses 1 to 4 and the schedule form part of the bill. Those in favor say aye. Those against say no. Ayes have it. Honorable members, I now put the question that the National Registration Amendment Bill 2022, Bill number 23 of 2022, be reported to the Assembly as printed. Those in favor say aye. Those against
Aye.
say no. Ayes have it. Let the Assembly resume. Honorable Attorney General and Minister of Legal
Thank you,
Affairs.
Mr. Speaker. I rise to report that the National Registration Amendment Bill 2022, Bill number 23 of 2022, was considered in committee clause by clause and was passed without amendments. I move that the bill now be read the third time and passed as printed.
Honorable members, the question is, and I put the question that Bill number 23 of 2022, the National Registration Amendment Bill 2022, be read a third time and pass as printed. Those in favor say aye. Those
Aye.
against say no. Ayes have it. Let the bill be read a third time.
National Registration Amendment Bill 2022, Bill number 23 of 2022.
Thank you, honorable members. I am advised that the two other bills, the Criminal Law Procedure Amendment Bill, Bill 2022, Bill number 21 of 2022, and the Court of Appeal Amendment Bill 2022, Bill number 22 of 2022, will be deferred along with the other motion on the order paper. This brings us to the end of our business for this 52nd sitting of the National Assembly. I am not too sure that we may meet again before the holidays season. So I want to take this opportunity to wish you and your families, along with the staff of the Parliament and the security forces, the media, and all those who have been watching, season greetings and a very happy new year. The Honorable Minister of Parliamentary Affairs and Governance.
Mr. Speaker, we would like to adjourn the sitting to a sign a day. But we are not certain whether we'll have a sitting before the end of the year. However, we will have, we'd like to extend greetings to everyone, you yourself, your family, and the staff of Parliament, to have a wonderful Christmas weekend, just in case we see you before New Year's. But at this point, I am not aware that we'll have a sitting before then. But I hope that everyone has a safe Christmas. COVID is on the rise again, and therefore I know at Christmas time everyone enjoys themselves and goes out and socializes, but I believe we need to be careful and yet nevertheless enjoy being with our families. Stay safe and drive carefully. Don't drink and drive. And I know none of you will do that, of course. And so all the best to you, and we hope to see you, if not before New Year, certainly in the new year, 2023. Thank you very much for all the support for this year in Parliament.
Thank you, Honorable Minister, Honorable Deputy Speaker.
Mr. Speaker, I would say thank you so much for this opportunity. I'd like to take it to wish all of my parliamentary colleagues, yourself, your family, your respective families, and all of Guyana, a very happy holiday season. It has been a very fruitful year, and I look forward to what the holidays will bring in terms of rest and relaxation and family time, and also to a bright future continuing in 2023. Happy holidays to everyone.
Thank you very much, Deputy Speaker. Thank you, Honorable Deputy Speaker, Honorable Ministers, Minister Teixeira. Honorable members, this is a good time to adjourn the sitting to a date to be fixed.